Okay, you to let me know which line you're actually using for the stream. So is it going to be the line that's labeled Jason Long, or is it going to be one of the call-in
It'll be
phone
Jason
lines?
Long.
Okay, thank you very much. And then do you know which, all right, never mind.
Judge, this is the court reporter. You have a second?
Of course I do, yes.
It is helpful when doing Zoom to get all the names in ahead of time, and I think I've got most of them, but do you know who's representing staff today doing the talking?
I believe it's Mr.
That's
Pringle.
correct.
Okay.
And I'm sorry for stepping on you guys.
Yeah,
Go ahead, Mr.
that's
Pringle.
correct, Judge. And I also have Mark Johnson's also in attendance for staff counsel.
Who's
Mark Johnson.
Okay, and then OPC?
Nathan Williams.
Okay. And then MAWC?
Yes, Dean Cooper and Jennifer Hernandez, and then Mr.
got
Timothy Left.
Okay. And then the commissioners we have here so far, Holtzman? Or is that Kenny?
It appears, yeah, we have the chairman, Ryan Sylvie, with us, and I have heard Commissioner Holzman introduce himself, but I have not identified his line yet. So I'm going to ask Commissioner Holzman to speak up again for us.
This is Commissioner Holzman. Is that enough to get me?
Call in user 4? Okay.
Got it?
I do have it, and I'm going to go back to mute. Thank you.
Thank you.
I believe Commissioner Coleman just joined us as well.
Did we hear Commissioner Coleman trying to speak up there? Please go ahead, Commissioner Coleman, if you're with us.
I am here. Can you hear me? Can you hear me?
We sure can. Thank you very much, Commissioner Coleman. Your line is actually identifying you by name today. That's very helpful. Thank you.
Thank you very much.
Okay, good morning, everybody. It's about 8:13 a.m. It appears that most of, if not all of the essential parties are gathering here. So I think we will be able to get started this morning right on time at 8:15. We'll do a quick preliminaries and then we'll get going. Okay, good morning, everybody. Let's get this proceeding, let's call this proceeding to order. We are now on the record. Good morning. Today is April 8th, 2021. The time is now 8:15 a.m. The Commission has set this time aside for an evidentiary hearing in case number SA 2021-0017, which is the matter of Missouri American Water Company's application for a certificate of convenience and necessity, authorizing it to install, own, acquire, construct, operate, control, manage, and maintain a sewer system in and around the city of Hallsville, Missouri. My name is Jana Jacobs, and I'm the regulatory law judge assigned to this case. As you know, the members of the commission are Chairman Ryan Silvey, who is present with us today, Commissioner William Kenny, Commissioner Scott Roop, Commissioner Maida Coleman, who is also present with us today, Commissioner Jason Holz, and Commissioner Jason Holzman. If any of the other commissioners join us at any point today, or if commissioners have to leave briefly and then return, I would just ask if you would all feel free to just speak up and let me know and let all of us know when you're present so that I can give you an opportunity to ask any questions you want and acknowledge your presence here today with us. Okay, so we will get started first with entries of appearance. If your current contact information is already included with your appearance in this case, you don't need to repeat all of that now. I'll leave that up to you. Please identify all counsel present today and the party that you're representing. So if you could just go ahead, Missouri American Water, please.
Yes, Judge, thank you. Dean Cooper and Jennifer Hernandez from the law firm of Bryden, Swearingen in England, PC. Our address is on record with the commission. Appearing for Missouri American Water Company. Also appearing for Missouri American Water Company is Mr. Timothy Luft of Missouri American Water Company, and his address is also on record with the commission.
Thank you very much, Mr. Cooper. And I see Mr. Luft. I haven't seen Ms. Hernandez yet this morning, but it might be another screen I need to click to. Okay.
I believe she is on the line.
Okay, oh, I see. Thank you very much. I see you now.
I'm here, Judge. Thank you.
Thank you, Ms. Hernandez. Okay, and now we can move on to appearances for staff, please.
Yes, thank you, Judge. Good morning. Travis Pringle with Mark Johnson on behalf of staff. Our contact information is also already in the record.
Okay, thank you very much. I see both of you here this morning. We can now proceed to Office of the Public Counsel, please.
Nathan Williams, appearing on behalf of the Office of the Public Counsel in the public P.O. Box 2230, Jefferson City, Missouri 65102.
Thank you very much, Mr. Williams. And now for Boone County Regional Sewer District, please.
Yes, thank you, Judge. Jennifer Griffin with Lathrop GPM, appearing on behalf of the Boone County Regional Sewer District.
Thank you so much. All right, so we can get started now. This hearing is being conducted via video and telephone conference for the convenience of those who do not need to directly participate in the hearing before the commission today. The hearing is also being streamed on the commission's website, which is at psc.mo.gov. Any non-public matters will not be streamed, and I'll rely on counsel to alert me to help me ensure that confidentiality is preserved today. Please silence your line unless you're speaking. Among counsel who are appearing by video today, I would ask that you remain present, although obviously if for privacy purposes you need to briefly terminate your video, I understand that. And also Mr. Williams has mentioned that he might have a connection problem today. If anybody starts having trouble with their video or audio connection, it's often helpful just to cut the video for that purpose. So please feel free to do so if that's going to help us have a better connection today. Any witnesses who will appear by video today need only remain visible by video during their testimony, and I would actually prefer that those folks don't leave their video on the whole time because it's hard for me to distinguish among the many faces when I have folks that I can see who are not actually witnesses. That may not, of course, apply to commissioners. I will leave it totally up to commissioners about whether they want to remain on video or not. If you feel like that's going to help you communicate with me, please feel free to do so. All right, and then I will also ask that witnesses remain available for recall for the duration of the hearing. So even after they've given their testimony and they've been excused from the stand, it's possible that we might need to recall them. We're trying to make sure we get this all done as efficiently as possible in one day. So hopefully your witnesses can accommodate that. If that's a problem for any of your witnesses, please let me know. All right, the chat function in this WebEx software is public and it is displayed to all participants who are connected to the video conference. It is not private and the chat is not part of the official record of this case. We will try to take breaks about every 90 minutes, and I'll look for a good opportunity to break for lunch sometime after 11:30, depending on how things are going. Please speak up if you need a break before that time for some reason. All right, so the parties have exchanged exhibit lists and have identified proposed exhibits, including any exhibits that were already filed in this case in the Commission's filing system. Does anyone have any remaining questions or concerns regarding any exhibits at this time? I know there were some amendments to exhibit lists. I didn't have a problem with those. Does anyone have any concerns that we should talk about before we get started? I do not see any lawyers who want to speak up and say anything, and no one has said anything. So I think I'm safely can conclude that you guys don't have anything to add here. So we're going to follow the order of opening statements, order of witnesses, and order of cross-examination proposed by the parties in the joint issues list that was filed in this case. That proposal was filed on March 22nd, and it didn't include a formal opportunity for Office of the Public Counsel to question witnesses. And I haven't had an opportunity to ask Mr. Williams if that's something that OPC anticipates doing today. So I will ask now. Mr. Williams, did you have any concerns about the fact that the parties have essentially proposed cross-examination that doesn't formally include OPC? Do you want me to give you an opportunity, or can we just allow you to speak up?
You can just allow me to speak up if I choose to, but I'm anticipating no cross.
Okay, thank you very much. Okay, so those were all the preliminaries that I wanted to cover. Do any of the parties have any additional matters that they would like to address before we proceed to opening statements this morning?
Judge,
Okay.
this is public counsel. I'll waive opening now.
Okay, thank you. I appreciate you clarifying that. Just give me 1 second to send a message and then we will get started with opening. Okay, I apologize for that little delay, but I just have to make sure everything is all right and people know what is going on. So now we are ready to move on to opening statements, and we will begin with Missouri American.
Thank you, Judge. This hearing is the most recent step in Missouri American's effort to purchase the Hallsville sewer system. On August 26th of 2019, the Hallsville Board of Aldermen passed ordinance number 370, which was styled an ordinance calling for an election in the city of Hallsville, Missouri, to be held on November 5th of 2019 for the purpose of submitting to the qualified voters of the city a proposition to sell certain assets associated with the city's wastewater system to Missouri American Water Company. Section 2 of that ordinance provided that if a majority of the votes cast on the question by the qualified voters voting thereon are in favor of the question, then the city may negotiate a contract with Missouri American Water for a price of not less than $2 million cash and a capital commitment of $3,300,000 over 5 years, including terms that provide for future service, maintenance, capital improvements, and other terms and conditions. The election was held on November 5th of 2019, and a majority of votes were cast in favor of the proposition. On July 14th of 2020, Missouri American entered into a purchase agreement with the city of Hallsville that has been provided in this case. Missouri American requests in this case a certificate of convenience and necessity to provide sewer service within the identified service area utilizing the Hallsville system. The commission may grant a sewer corporation a CCN to operate after determining that the construction and/or operation are either necessary or convenient for the public service. There are currently violations of Hallsville's operating permit that result in discharges that eventually enter waters of the state in violation of the Missouri Clean Water Law, as well as other compliance problems. As a result of the numerous compliance issues documented over the years by the Missouri Department of Natural Resources, the Hallsville facility is under enforcement with MDNR's Water Protection Enforcement Section. The Commission has articulated criteria to be used when evaluating applications for utility certificates of convenience and necessity. These are sometimes called the Tartan Factors. Those factors are as follows. 1, there must be a need for the service. 2, the applicant must be qualified to provide the proposed service. 3, the applicant must have the financial ability to provide the service. 4, the applicant's proposal must be economically feasible. And 5, the service must promote the public interest. There is a need for the service in this case, as residents currently make use of the existing sewer system, and there are known compliance violations that must be addressed. Missouri American is qualified to provide the service, as it already provides safe, adequate, and compliant water service to over 470,000 Missouri customers and sewer service to over 15,000 Missouri customers. Missouri American has the financial ability to provide and improve the service. Missouri American's feasibility study indicates that the purchase of the city's sewer assets will not generate positive income in the initial years. However, Missouri American's financial standing is such that this situation will not impact its ability to provide safe and adequate service. And there's likely to be no impact from this transaction on Missouri American's general population of ratepayers. Further, Missouri American possesses adequate technical, managerial, and financial capacity to operate and improve the sewer system it wishes to purchase from the city. The Commission has indicated in the past that positive findings with respect to the other 4 Tartan factors will in most instances support a finding that the application for a CCN will promote the public interest. The factors for granting a certificate of convenience and necessity to Missouri American in this case have been satisfied, and it is in the public's interest for Missouri American to provide sewer service to the customers currently served by the city of Hallsville, as called for by the actions of the Board of Aldermen and the vote of the people. There is a further question as to what conditions, if any, the Commission should impose in conjunction with any CCN it may grant in this case. Missouri American agrees that the Commission should authorize the transfer of assets and grant Missouri American the CCN to provide sewer service within the proposed service area, subject to the conditions proposed by staff. The Boone County Regional Sewer District proposes 5 additional conditions in its statement of position. Missouri American does not object to the district's proposed conditions 1 and 2. However, Missouri American would object to the district's conditions 3, 4, and 5. District condition 3 would grant essentially the district veto power in regard to any plans to address the system's capacity and compliance issues for an indefinite period of time. DNR already exists for the purpose of regulating those issues. District condition 4 would mandate a certain treatment process for Hallsville, again without regard to the decisions of the entity responsible for such issues, that being DNR. And district condition 5 would require ownership of certain land where other treatment options might be acceptable. Again, there's no need for the Commission to get into regulation of what type of treatment should be used when that is ultimately a DNR matter. Lastly, the district argues that there should be an issue in this case as to certain DNR regulations concerning continuing authority and DNR permits. The term continuing authority means the permanent entity that will be responsible for the operation, maintenance, and modernization of the sewer system for which the permit application is being made to DNR. The district argues that it is a level 2 continuing authority within the incorporated city of Hallsville and over the sewer system owned by the city. Missouri American believes that is not the case based upon the actions of the Clean Water Commission, previous actions of the Clean Water Commission. But even if DNR were to find that the district is a level 2 authority regarding the Hallsville system, there are exceptions to the continuing authority hierarchy that allow a lower authority to operate a system. At the end of the day, the commission need not resolve this continuing authority issue. This issue concerns DNR regulations associated with permitting and should be resolved by DNR. A grant of a CCN by this commission is the next step in bringing that issue before the Missouri Department of Natural Resources. Judge, the commission should grant Missouri American a certificate of convenience and necessity to provide sewer service within the proposed service area, subject to the conditions described by staff. And that's all I have at this time.
Thank you very much, Mr. Cooper. I had contemplated that we would have questions for council after all opening statements had been made, but I understand that Chairman Sylvie needs to leave this morning for important meetings at the Capitol at 9. And so I just wanted to give Chairman Sylvie an opportunity to ask Missouri Americans Council any questions he might have at this time in case he'd like to.
I appreciate that, Judge. I have no questions at this time.
Okay, so I think what I'll do then is probably, it looks like we have Commissioner Roop joining us. So I think I'll just proceed then and we'll take an opening statement from staff and then I will open the floor to questions. I'm sorry, Commissioner Holzman?
Commissioner Holzman. Yeah, I just had one real quick question.
Please go ahead, sir.
What was the vote count? You said that the vote had passed in 2019. I'm just curious what the end result was of that count.
Judge, I don't have that, or I'm sorry, Commissioner, I don't have those numbers right in front of me, but I will grab those and get those to you during the course of the hearing, if that would be okay.
Okay, thank you very much. No further questions.
And I don't recall seeing information about that vote offered by any party to this point in this case, unless I happen to miss that fact. So I don't think it's in any information that has been offered at this time, unless I overlooked it.
It may be in the application.
Okay, it was just more of a curiosity. I just was interested to see what the public support was for the proposal.
Okay, and the court reporter may have trouble with folks speaking up without us knowing who they were. There was someone who just said it may have been in the application. Who was that person?
That was Mr. Luft, Judge.
Okay, thank you, sir. Mr. Luft, if you have anything to add there, you can go ahead and finish your statement.
I think that's in our application, and I will check and then update if that's in there. The vote.
The actual vote tally is something that you think was in the application.
Typically, we put that in there. I'll double check.
Okay, thank you. Okay, thank you.
I have the numbers, Judge, if Commissioner Holden would like to hear them.
Okay, please
Yes,
proceed, Mr. Pringle.
Yeah, the vote was 136 to 64 in favor, so 68% of the vote was in favor.
And
Thank you
Mr.
very
Pringle, did you locate that in some documents that are in fact in the case file in this case?
It is on the application, I believe.
Okay, thank you. I overlooked that. Is it an attachment or it's simply recited in the application as a fact?
Recited in the application, I believe. I think it may also be in Mayor Carter's testimony as well.
Okay, well, perhaps Mayor Carter's testimony today will give us a chance to revisit that.
Okay.
Were there any additional questions that came out of Mr. Cooper's opening statement? Okay, I believe that we were ready then to proceed to opening statement from staff, please.
Thank you, Judge. May it please the commission. My name is Travis Pringle, and together with Mark Johnson, we represent the staff of the Missouri Public Service Commission. I'm here today to explain what is necessary or convenient for the public service. I'm here to explain staff's recommendation to approve the Missouri American Water Company's request for a certificate of convenience and necessity. I'm also here to help you understand the process that led to staff's recommendation. The Commission has jurisdiction over applications for certificates of convenience and necessity, or CCNs, under Section 393.170 RISMO. Under the CCN statute, the Commission may approve a CCN application if it is found to meet the standard of necessary or convenient for the public service. Under statute, there is no specific criteria as to when a CCN is necessary or convenient for the public service. Now, while guidance has not been laid out under statute, the Commission has tools to refer to in helping it reach a decision as to whether an application is necessary or convenient for the public service. The Commission has issued its own rules through 20 CSR 4240-3.305, outlining the filing requirements of every CCN application for sewer service. This is in addition to the blanket application rules found at 20 CSR 4240-2.060. These rules can act as a guide map in helping the Commission determine if an application is complete and sufficient. The Commission may also look to the courts for guidance as to what would be necessary or convenient for the public service. In Intercon Gas, the courts have stated that necessity does not mean essential or absolutely indispensable. Rather, necessity refers to an additional service which would be an improvement justifying its cost. To quote Missouri Coach Lines, any improvement which is highly important to the public convenience and desirable for the public welfare may be regarded as necessary. If it is of sufficient importance to warrant the expense of making it, it is a public necessity, end quote. Intercon Gas further holds that the decision of whether the evidence indicates the public interest would be served in the award of the certification falls within the discretion of this Commission. This necessary or convenient for the public service standard is applied in every CCN application that comes before the Commission, and it is a standard that staff concludes has been met by Missouri American Water. When applying for a CCN, the burden of establishing that an application is necessary or convenient for the public service rests on the applying party. In this case, that burden rests on the Missouri American Water Company. The Commission determines if Missouri American Water has carried this burden if the preponderance of the evidence shows so. By that, I mean the greater weight of the evidence leans toward the party having carried its burden. Missouri American Water applied for a CCN to install, own, acquire, construct, operate, control, manage, and maintain a sewer system in and around the city of Hallsville, Missouri on July 20th, 2020. This application was the result of public meetings, a vote by the people of the city of Hallsville, and the signing of a purchase agreement dated July 14th, 2020, between the city's elected officials and Missouri American Water to sell the sewer system. On July 23rd, 2020, the Commission ordered staff to begin its review and investigation. Staff reviews the application to ensure that the applying utility complies with the requirements of 20 CSR 4240-2.060 and 3.305. This is the standard process employed by staff, and compliance with the rules is a requirement for a utility seeking a CCN before the Commission. Of further use for staff in investigating a utility's application for a CCN, especially when, as today, the CCN is to acquire an already existing system, is reviewing the applicant's technical, managerial, and financial capabilities to run the system. This is known as TM&F. TM&F capacity helps lead to sustainable systems. For example, technical capabilities refer to an applicant's capacity to meet the engineering and structural integrity requirements to serve the needs of its customers. Managerial capabilities refer to the applicant's managerial capacity to properly manage the system. And the financial capabilities refer to an applicant's ability to raise and properly manage the money required to operate a system over the long term. In its recommendation to approve, staff concluded that Missouri American Water Company exhibits the necessary TMNF capacities to provide service necessary or convenient for the city of Hallsville. Staff also employs the Tartan criteria to ensure that a utility is qualified to provide service. These criteria are: 1, there must be a need for the service; 2, the applicant must be qualified to provide the proposed service; 3, the applicant must have the financial ability to provide the service; 4, the applicant's proposal must be economically feasible; and 5, the service must promote the public interest. Over the course of staff's investigation, staff concluded that Missouri American Water Company meets the Tartan criteria. Having concluded its review per the CCM process as outlined under statute and in the Commission's rules, staff concluded that the granting of a CCN to Missouri American Water to install, own, acquire, construct, operate, control, manage, and maintain a sewer system in and around the city of Hallsville is necessary and convenient for the public service. That being said, staff also included 18 conditions that it recommended the Commission include in an order granting Missouri American Water's application. Missouri American Water agreed to all 18 conditions outlined by staff in its response to staff recommendation filed on December 4th, 2020. In its position statement filed on March 24th, 2021, the district also expressed its agreement with staff's conditions if the Commission were to grant Missouri American Water's application. Today, you'll hear from staff witnesses Jim Bush, Jared Robertson, Matthew Young, and Deron Williams. I implore you to ask them questions. Ask them how staff investigated and reviewed Missouri American Water's application. Ask them how staff determined Missouri American Water's application is convenient or necessary for the public service. Ask them how Missouri American Water exhibited the requisite TMNF capacities and met the Tartan criteria. They are here to provide you information and aid in your understanding of staff's recommendation in this matter. And I do want to make a note about a term you may hear a lot about today, and that is continuing authority. Continuing authority is outlined under the Department of Natural Resources rules, specifically 10 CSR 20-6.010 sub 2. Continuing authority can play a factor in Department of Natural Resources issuing of an operating permit, which Missouri American Water would need before it can operate the Hallsville sewer system. The district put forward its level 2 continuing authority as a reason for the Commission to deny Missouri American Water's application, because it is a level 3 continuing authority, lower than the district. The district has put forward that awarding Missouri American Water a CCN in this case would usurp their long-term planning authority and right to decide how best to achieve regionalization within Boone County. Continuing authority is not something that is determined by this Commission. It is a determination made by the Missouri Department of Natural Resources. The Department of Natural Resources issues and assigns continuing authority levels, not this Commission. The Department of Natural Resources grants waivers regarding continuing authority per DNR Rule 10 CSR 20-6.010 sub 2C, not this Commission. There is no mention of continuing authority in the Commission's rules or founding statutes. The Commission has no jurisdiction over continuing authority. In fact, Department of Natural Resources Rule 10 CSR 20-6.010 sub 2B3 outlines that the only way that Missouri American Water can apply for an operating permit as a level 3 continuing authority is to first receive a CCN from this Commission. As I stated earlier, continuing authority is but one factor that DNR reviews when determining if an applicant is to be granted an operating permit. This is a process that happens every time the Commission grants a CCN for sewer service, and the intervention by the district in this matter does not change that process. It is staff's opinion that the law clearly states that the issue of continuing authority is to be decided by the Department of Natural Resources. The Commission is here to determine if the award of a CCN to Missouri American Water is necessary or convenient for the public service. It is clear that Missouri American Water will have to, when applying for an operating permit, deal with this issue. But that issue is to be decided by Department of Natural Resources, not this Commission. And deciding what is necessary and convenient for the public service is an issue to be decided by this Commission, not the Department of Natural Resources. Staff does not deny the district has a clear interest in who owns and operates the Hallsville sewer system. Staff reviewed the documents submitted by the district with its intervention, including its long-term plans and greater jurisdiction per its higher-level continuing authority. Staff considered the impact of the district's interests on Missouri American Water's application. It should be stated, however, that the district had an opportunity to acquire the system before today. The City of Hallsville asked for interested parties to submit bids to buy its sewer system no later than November 1st, 2019. The city received bids from Missouri American Water, the district, and Liberty Utilities. The people of Hallsville then approved by vote to move forward in selling its sewer system during a November 5th, 2019 election. All three interested parties were then invited to present their proposals before the Board of Aldermen on January 22nd, 2020. The elected officials reviewed the bids, and in the end, they chose Missouri American Water. By sticking to the process outlined by the General Assembly via Section 393.170 and the rules embraced by this commission under 20 CSR 4240-2.060 and 3.305, as well as taking into account all of the evidence submitted, staff concludes that Missouri American Water's application to install, own, acquire, construct, operate, control, manage, and maintain a sewer system in and around the city of Hallsville is, by a preponderance of the evidence, necessary or convenient for the public service. And I have nothing further. Thank you.
Thank you very much, Mr. Prinkle. I think it would be appropriate to proceed now to the district's opening, and then we'll take any questions for staff and the district after that.
Thank you, Judge. Good morning. This case involves an unusual fact pattern. Missouri American is a privately owned provider of wastewater services. It seeks a certificate of convenience and necessity to enable it to acquire and privatize Hallsville's public municipal wastewater system. The Hallsville system is undisputedly located within the boundaries of the Boone County Regional Sewer District and serves customers in and around Hallsville, including customers of the district. The district is a public sewer district formed by a vote of the citizens of Boone County. By statute, of Boone County. The district has long-term planning powers within Boone County under Chapter 204 of the Missouri Revised Statutes, state regulations, its regulations, and its approval by the Missouri Clean Water Commission as a Level 2 continuing authority. For decades now, the district has exercised this authority in Boone County with a mission to eliminate discharges of wastewater to waters of the state in Boone County for the protection of the environment and the public health. It has done so by developing an area-wide management plan consisting of facility plans for different areas of Boone County. The district has a facility plan that includes the Hallsville service area. Under state law and the district's sanitary sewer regulations, the city of Hallsville is authorized to own and operate a municipal wastewater system that is exempt from regulation by the jurisdiction. Missouri American, however, is not. By regulation, if Hallsville no longer wishes to own and operate its system, it must tender the system to the district. Hallsville does not have the option to sell the system to Missouri American, and Missouri American does not have the option to purchase the system. The district is unwilling or unable to own and operate it and gives consent to privatization by Missouri American. In addition, under the district's regulations and Level 2 continuing authority approval, the Missouri Department of Natural Resources lacks authority to issue Missouri American a state operating permit for the Hallsville system because Missouri American's privatization of the system would conflict with the district's regulations and approved area-wide management plan for Boone County, where, as here, the district has indicated that it is willing and able to own and operate the system and that it objects to privatization. In order to grant Missouri Americans' request for a certificate of convenience and necessity, the Commission must find that the fifth Tartan factor is met. And that factor has been referenced already by council. It is promoting the public interest. The CCN must promote the public interest in order for it to be issued to Missouri American. It does not here. The unique facts here do not support a finding that granting Missouri American a certificate of convenience and necessity promotes the public interest, because its privatization would be facilitated by the grant of such a CCN and is contrary to the public interest because it interferes with the district's exercise of its authority and will result in the district and Missouri American expending resources in DNR permit litigation that are better used to protect the environment and public health. Accordingly, this commission should find that Missouri American does not meet all the necessary criteria for the requested CCN and does not deny Missouri American's request. Alternatively, should the commission consider issuing the requested CCN, the district submits and requests that the commission needs to impose reasonable conditions to mitigate the conflict between Missouri American's privatization of Hallsville system and the district's area-wide plan. These conditions were outlined in the district's position statement and are as follows. 1, limit Missouri American service area to the Hallsville city limits, specifically excluding any areas outside the city limits other than those where the current storage basins and land application fields are located, absent a valid contract between Missouri American and the district. 2, require Missouri American to obtain an operating permit from DNR within 2 years of the effective date of the CCN. 3, require Missouri American to obtain the district's consent for any plan to address the Hallsville system's capacity and compliance issues. From submitting applications for construction or operating permits to DNR that seek approval to convert the Hallsville system from a no discharge facility to a discharge facility. And 5, require Missouri American in any plan involving an irrigation system to own any land used for land application of wastewater flow collected by the Hallsville system. In conclusion, the district respectfully requests the commission to deny Missouri American's request for a CCN. Thank you.
Thank you very much, Ms. Griffin. So we can proceed now to any questions from commissioners for staff counsel or for the counsel for the district. Any commissioners, if you had any questions, please just speak up.
No questions, Judge. Thank you.
Thank you, Judge. This is Commissioner Sylvie. Do DNR's regulations require a sewer system to get a CCN from the PSC first?
Good morning, Chairman Sylvie. This is Travis Pringle from staff. Yes, there is in the DNR regulations, since MAWC is a level 3 continuing authority, they do need the CCN from us first before they can apply for an operating permit.
Okay, so then would that mean that DNR will only consider the application of a system that has a CCN?
Correct. If MAWC were not to receive a CCN from this commission, they can't move forward to try for an operating permit.
Okay, thank you.
And it sounded like Commissioner Holzman indicated he did not have any questions. And if I believe we have Commissioner Coleman and Commissioner Roop with us as well. I do have a couple of questions for counsel for the district. And of course, commissioners are always invited to interrupt and speak up. There's one question, Ms. Griffin, I wanted to ask you about one of the conditions in the alternative that the district has proposed. And this is related to the requirement that a permit be obtained from DNR within 2 years. And I was wondering what the difference is between requiring the permit within a 2-year period and the provision under the statute, section 393.170.3, which requires a certificate holder to exercise that certificate within 2 years. I just wanted to understand if there's a difference between those two provisions and the condition that the district has proposed.
There was not intended to be a difference, Judge.
Okay, so that condition is really just kind of emphasizing that there is a 2-year limit under statute.
Correct.
Okay. It seems like there could possibly be an issue as far as what constitutes exercising a certificate. However, do you think that that's true, or would you see the only way that the certificate is exercised is by obtaining the permit?
The latter is how I viewed the law.
Okay, I don't know if staff counsel would have anything to say on that point.
I know we've faced complaint before about what it means to exercise a CCN, Judge. So really, I couldn't tell you until they were to get that operating permit. Personally, I would see that as exercising it, but we have had cases regarding what is exercising a CCN.
Okay. Did any other party have anything to say on that point, perhaps counsel for the company?
Only, Judge, that I would agree that while that language is in the statute, I'm not familiar with any case or any further guidance beyond what is those words are in the statute in terms of what it means to exercise a certificate. So I think that's an open question.
And if I understood you correctly this morning, the company was indicating that this particular requested condition was not something that the company would have a problem accepting. Is that right?
That's correct.
Okay. Another question for the district, and this question is simply about the request that the condition the commission might impose would prohibit Missouri American from converting the Hallsville system to a discharge facility. And my question for council there was, doesn't the Clean Water Commission have the authority to refuse a discharge permit?
Yes, they do, Judge, but it's the district's position that its regulations also would prohibit that solution to the compliance issues being experienced at the Hallsville system, and the district believes it is appropriate for Missouri American to be required to coordinate any solution that would involve such a conversion with the district under its regulations.
Okay, and so your references to the district and its regulations are, could you clarify for me what you're referring to? Are you referring to the district's management plan or some other document?
I'm referring to the district sanitary sewer regulations, which are included in the materials that were pre-filed as part of the facility plan. That includes the Hallsville service area.
And that must be part of the extensive schedules that are attached to Mr. Ratterman's testimony, is that right?
Correct. It's scheduled
okay.
TR1.
Thank you very much for clarifying that for me. Okay, those were the only questions that I had. I don't know if the company or staff council had any additions that they would like to make there after having heard from Ms. Griffin. Doesn't appear so. And unless we have any questions for council, we are ready to proceed to start hearing from witnesses. Does anyone have anything to add before we go ahead and get started with our first witness? Okay. According to the information I have, we should be hearing from Mr. Horan. Give me one moment here while that individual gets his video lined up, and I'm going to send a message. I'll be right back. Okay. Thank you all very much for your patience with me this morning. It appears that we have Mr. Haran by video this morning. Sir, could you speak up to make sure we can hear you?
Yes, Judge, can you hear me?
Yes, we can hear you very well. Okay, so the first thing that we need to do is get you sworn in. Could you raise your right hand, sir? Do you solemnly swear or affirm that the testimony you will give in this hearing will be the truth?
I do.
Okay, counsel for Missouri American, you may proceed with your witness. Thank you.
Thank you, Judge. Mr. Haran, would you go ahead and state your name for the record?
Yes, my name is Matthew Haran.
And by whom are you employed and in what capacity?
I am employed by Missouri American Water Company. My employment title is Senior Operations Manager for our East Central Division.
Have you caused to be prepared for the purposes of this proceeding certain direct and rebuttal testimony in question and answer form?
I have.
Is it your understanding that that testimony has been marked as exhibits 1 and 3 in both public and confidential form?
It is.
Now, Judge, I'm going to ask Mr. Haran about changes, and we had provided the errata sheet to you yesterday. We'll work from that. I don't know whether you want to do anything else with the errata sheet or mark it or how you would like for us to handle that.
I think that it probably needs to be marked as an exhibit to make sure that it gets in the record in writing, and then you can go ahead and work from it in your in Mr. Haran's testimony as well today. Does that work for you?
That's fine. Judge, we would ask then that the errata sheet be marked as Exhibit 7.
Okay, we will mark that as Exhibit 7.
Mr. Haran, do you have before you the referenced errata sheet that has now been marked as Exhibit 7?
I do.
Does that sheet represent changes that you have to your rebuttal testimony?
Yes, it does.
Okay. Would you go through those for us one at a time?
Yes, so the first correction to the testimony is on page 5, line 5. And Hallsville's current rates at closing.
And then the second change?
The second change is on page 8, line 2, and we are just striking the word highly out of the testimony.
And the third change?
Third change occurs on page 8, line 8, and the last word on the line should be an A, not an and.
And then the final change?
The final change occurs on page 10, line 19. The first word on the line should be such.
And are those all the changes you have to your testimony?
They are.
If I were to ask you the questions which are contained in Exhibits 1 and 3 today as now corrected, would your answers be the same?
They would.
Are those answers true and correct to the best of your information, knowledge, and belief?
They are.
Judge, at this time I would offer Exhibits 1P, 1C, 3P, 3C, and the errata sheet, Exhibit 7, into evidence and tender the witness for cross-examination.
Are there any objections to the admission of those exhibits which constitute Mr. Haran's pre-filed testimony in this case and the errata sheet? Hearing no objections, those exhibits will be admitted to the record. And we can proceed to cross-examination. We will start with staff.
Thank you, Judge. Good morning, Mr. Haran.
Good morning.
How many sewer customers are served by Missouri American Water Company?
I don't have the exact number off the top of my head right now, but I believe it's somewhere in the neighborhood of 15,000 customers in Missouri.
And how many wastewater treatment facilities does Missouri American Water operate in Missouri?
To the best of my knowledge, it is 73 wastewater systems.
And I'm correct in stating that Missouri American Water is a level 3 continuing authority?
That is my understanding, yes.
And when it comes to the issuance of continuing authority, is that more to do with operating permits or CCNs?
To my understanding, it has to do with operating permits.
And where would a sewer utility go to receive an operating permit?
We would go to the Missouri Department of Natural Resources.
Thank you, Mr. Hernandez. I have nothing further at this time.
Thank you.
And we will now hear from the district for
Thank you, Judge.
cross-examination.
Good morning, sir.
Good morning.
Has Missouri American seen the contracts between the city of Hallsville and the district under which the Hallsville system is to serve the district's customers in Sunny Slope and Silver Creek subdivisions?
We have.
So Missouri American is aware these contracts do not expire until 2039?
I believe that's what's on those contracts, yes.
And does Missouri American continue to take the position that it has no obligations under these contracts?
I'm not an attorney, so I'm not sure to go through them, but I know we are committed to working with the district to make sure that we will continue treatment of wastewater from those subdivisions.
Do you know if Missouri American has provided any draft contracts to the district that would be between Missouri American and the district for service at the Sunny Slope and Silver Creek subdivisions?
I am not sure if anything's been provided to the district, but I know Consul has worked up has been working on some draft agreements and is willing to get with the district on those.
Does Missouri American have any intention of serving future customers of the district in areas of unincorporated Boone County or Silver Creek subdivision?
We do not. I can't speak for the entire county.
Okay. Has Missouri American evaluated the impact of its purchase of Hallsville system on the district's long-term planning for the regionalization of sewer services within Boone County?
We have not.
Has the district done any evaluation of the impact of its purchase of Hallsville system on the district's operations?
Can you repeat that question?
Sure. Has Missouri American evaluated at all what the impact might be of it purchasing Hallsville system on the district's operations?
No.
And did you have any involvement in the process followed by the district to obtain the Missouri Clean Water Commission's approval as a level 2 continuing authority?
I did not.
Do you know if anyone at Missouri American did have involvement in that process?
I do not know that. I believe it was back in the 70s.
Okay. So the only information that Missouri American has regarding that approval issued by the Missouri Clean Water Commission are the schedules that are attached to your rebuttal testimony that are attached to.
That is my understanding.
And would you agree on behalf of Missouri American that Hallsville's current practice of land applying Hallsville's wastewater effluent is not a long-term solution for the Hallsville facility?
I do agree with that. We believe some other type of treatment is necessary.
Okay. And is part of the reason that would not be a long-term solution because of the dependency on the local landowners, Mr. Martin and Mr. Teal, from whom the land application fields for the Hallsville system are leased?
Yes, that is correct.
And would you also agree that Hallsville has indicated it has had issues with these landowners for years in terms of them complying with the contracts with the city?
I would agree with that.
And in your rebuttal testimony, you testified as to two different irrigation options as a solution, a long-term solution for the Hallsville facility. And you indicated that Missouri American would need to purchase land to have an irrigation option or modify and continue the agreements with landowners / partners cooperation.
Do.
Okay. And my question to you is, based on the history of issues with landowners, Mr. Martin and Mr. Teal, how would modifying and continuing the agreements with these individuals be a viable solution for the Hallsville system?
I believe we would need to modify the agreements and get more language in there to make sure that they are following the operating permit.
If this commission grants Missouri Americans' request for a certificate of convenience and necessity, how long does Missouri American anticipate operating the Hallsville system before selecting a long-term solution?
That is unknown at this point. We have stressed along the process that we would like to make sure we operate it for a period of time to collect all the data necessary and vet all the options that we are considering as of now, knowing that there may be some more options out there that we're not considering at this point.
Does Missouri American intend to involve the district in its process for selecting a long-term treatment option?
No, we do not.
Nothing further, Judge.
Thank you very much. At this point, we will take any questions that we may have from commissioners. I will also have some questions for Mr. Horan, and so anytime commissioners would like to ask questions, just go ahead and speak up. Okay, the first thing I wanted to address before we get to additional questions for Mr. Horan is we did hear some testimony about agreements that are in place between Hallsville and the district in regard to providing service to some subdivisions. And my understanding is that those agreements were attached in a pleading filed by the company on August 31st. They appear to be Appendix E and Appendix F. And that includes an ordinance from the city of Hallsville and then the attached related contracts that apparently arose out of that authority. I would propose that it would be helpful for the commission's decision in this case to actually have those documents in the record rather than just testimony and references to them. So I would propose that as Commission's Exhibit 303, we would admit the contents of Appendix E, which was attached to the August 31st filing by the company, which constitutes the Hallsville Ordinance 358 and the cooperative agreement between the district and the city regarding Sunny Slope. And then Appendix F would be included on the record as Commission Exhibit 304. That should be composed of Hallsville Ordinance 362 with the attached cooperative agreement between the district and the city in regard to the Silver Creek subdivision. I think that adding these documents to the record is potentially going to be helpful for further testimony today and for the commission's decision. Are there any objections to that from any party?
No objection.
Okay, then we will admit those documents as I have described them. And after they are filed, the parties will have an opportunity to verify that exactly the precise documents were selected and filed. Okay? All right, so we can proceed now with questions that I have for Mr. Horan. The first thing I would like to ask you about is you just clarified your testimony through the errata statement to indicate that the company's proposal is to use the rates that are currently charged by Hallsville at the time of closing. Is that correct?
That is correct.
Okay. So I have questions for you about the figures or the numbers that are used in the feasibility study that is attached to your testimony. And I understand that the feasibility study as a whole is a confidential document. However, the proposed rate to be paid in on the Hallsville system if the company gets a CCN and actually gets an operating permit, the amount that would be proposed to be charged to customers, my understanding is that that is not a confidential element of that feasibility study. Counsel for the company, do you agree?
I would agree with that, Judge.
Okay, so I'm going to ask you about that, but obviously not trying to breach any confidentiality. Are you able to look at the feasibility studies, Mr. Haran?
I am.
Okay. Could you look at what is the amount is indicated to be charged Hallsville customers in that feasibility study? And please tell us what that is.
Yes, the amount in that study is $38.75 flat rate.
Okay. And are you familiar with the amount that Missouri American's application indicates it intends to charge customers in Hallsville?
Yes, I am.
And what amount is that?
That was the current rates that Hallsville was charging. From memory, I believe it was $19.35 for the first 1,000 gallons and $5 per 1,000 gallons, additional 1,000 gallons thereafter.
Okay, your memory appears to be pretty good because I do believe those are the amounts that are stated in the application. So can you explain to me the difference, the apparent difference between what's in the feasibility study and what's in the application?
I just believe when we filed the application that we had an improper rate in there. The $38.75 that was originally identified in the feasibility study is our intention.
And what is the source of the $38.75 rate?
That is the current rate that we charge smaller sewer systems outside the city of Arnold as authorized by the PSC.
Okay, and so I had previously informed the commission had previously informed the parties that we may need to bring into the record Missouri American's current rates under its existing tariffs. And that was a proposed Exhibit 300, Commission's Exhibit 300. So I would propose, based on Mr. Haran's testimony today and his reference to the current sewer rate, that Exhibit 300 that was disclosed to the parties be admitted to the record. Does anyone have an objection to that? Okay. Commission's Exhibit 300 will be admitted to the record. Okay, so then I do require then some additional explanation, Mr. Haran, because I think your testimony today posing to adopt Mr. Haran because they've charged in Hallsville at the time of closing. Is that right?
That is correct.
Okay, and then what is the relationship between that rate and what is stated in the feasibility study?
So the rate that Hallsville is charging right now, they're actually in the process of redoing their rate structure to have it as a $38.75 flat rate.
Okay. Okay. And then we have heard some testimony and statements by counsel, and also in your testimony, you've indicated that the Hallsville system is under enforcement with the DNR's Water Protection Enforcement Section. Can you tell me anything more about what that means? Do you know what it means to be under enforcement?
So I'm not a water quality expert, but I do know under enforcement, the DNR basically follows up with the municipality or the sewer or water purveyor to make sure that they are continuing to improve their system to get it up to the standards of the state. And typically there are financial implications involved in that.
Okay, thank you. The another question I wanted to ask you was whether the company serves any sewer customers or holds any certificates of convenience and necessity in Boone County.
I don't believe so, but I do not know that answer 100%.
Okay, so you're not 100% confident about whether Missouri American is operating in Boone County for sewer services at this
Correct.
time? Okay. Does the company currently serve any water system customers in Boone County?
Again, I don't believe so, but I would have to double check.
Okay. And does Missouri American currently operate any sewer systems in Missouri that use land application in the way that the Hallsville system uses land application at this time?
I'm not familiar with every sewer system that we have in the county. I'm not aware, but once again, I do not know that answer.
Okay, so so it sounds like you're not aware of any systems operated by the company that use land application in Missouri, but there could be some you simply don't know.
Correct. Yes, because we have operations all over. I'm not familiar with each individual one.
And in your role, in your job, are you supervising the use of land application in any of those systems?
I am not.
Okay. So could you explain to us what your understanding is of the feasibility study that's submitted to the commission with an application for a certificate and how that relates, if at all, to any improvements that a new operator might want to make to a system after acquisition?
Again, I do not believe it's in there, but that is all handled by our staff accountants on board and prepared for us through our experts, and I am not an accounting expert on that.
Okay. Can you tell us how urgent Missouri American views the need to upgrade the Hallsville sewer system?
Yes, as soon as we were able to get the CCN and begin to operate the system, we immediately plan on checking numbers, verifying effluent parameters, and working towards a better solution because, as stated in my testimony, we do not believe land application is the best option here in Hallsville.
Do you have any idea of the time frame in which the company would expect to or introduction of any upgrades to the Hallsville system?
Type of treatment option that we did, how long it would actually take to design it. So there's no set thing for that, but I know it's something we're not looking to push off for 5 years or anything. It would be immediately after we would start looking into it.
All right, and then I wanted to ask you about one of the statements that you've made in your testimony. I believe that I'm restating it accurately here. You said that Missouri American can make the upgrades needed to achieve compliance with DNR requirements while keeping customer rates lower than those that would be assessed by Hallsville. And I'm paraphrasing to some degree. This appears in your direct testimony on page 10. So I just wanted to ask you to please explain to us why Missouri American would be able to upgrade this system, comply with DNR requirements, but without raising rates to the degree the city would have to.
Sure. So we are in a situation unlike the city where the city has 600, I believe it was 664 connections to their sewer system, and they have a limited base that they're able to spread those charges out over. With Missouri American being statewide, we have different rate groups that allow us to spread charges over larger customer bases, thus resulting in a less price. Sorry, Judge.
I apologize. That was my fault. I stepped on you. Shouldn't have done that. Okay, I want to ask you about something that does appear in a confidential item in Schedule MH5C. And I am hoping that it will be possible to discuss it without getting specifically into information that is confidential. However, if it is not, we can go into a private breakout session to have an in-camera discussion. And so what I'm going to do is just let you and your council know what I'm going to ask about, and you guys can assess whether we can do that without breaching confidentiality. Basically, my question relates to one of the estimates that is provided in 5C. And in particular, it is for one of the estimates that includes two figures, essentially. And this is for what was dubbed the triple point. Okay, so I was not able to understand, based on the testimony that I have seen on that estimate, what that estimate means because of the larger figure appearing above it and then a much lower figure underneath. And I didn't understand what that was indicating. As I described this, I'm starting to think we would have to discuss this in camera, but perhaps not. Mr. Cooper, do you see what I'm talking about why that is?
I see what you're referring to, Judge. Yes. And I mean, I guess if the question is, what's the difference between those figures without specifying the numbers, I suspect we can do it in a public session.
Yeah, like, okay. Right, breaking down, okay, the first set of figures was supposed to describe this, and then the second set of figures is describing this. If it's possible to do that in public, that's fine. If we feel like it's going to be too vague, like I said, I can pull us into an in-camera.
Well, we can certainly give that a try if Mr. Horan thinks he can approach it that way.
Mr. Horan, what's your confidence level on what I'm trying to figure out here and your access to the terminology to describe it without breaching confidentiality?
I think I can do it without breaching confidentiality.
Okay. All right. So did you find the part of Schedule MH5C that I'm talking about that provides two different figures?
Yes, I did, Judge.
All right. And I suppose that you have a better idea of what is truly confidential here and what is not. So the description of this particular option, would you consider that to be confidential information?
I do not.
Okay, so could you describe it for me then, just as it's labeled?
Yes, Judge, and I do see the confusion that we have here. These estimates were prepared by some of our experts in our engineering department. And what a triple point system is, it's specifically for removing ammonia is one of the big things it is. The first figure, from my understanding from my engineers, is for us treating 100% of the flow. The second figure would still be utilizing some type of irrigation, so it would be a slightly smaller system with a little bit less flow.
Okay, so essentially it's an estimate that shows either introducing a system that's for the whole treatment or kind of a hybrid where you would introduce this treatment method for some portion of the wastewater and then still use irrigation for some other portion.
That is correct. It's my understanding, excuse me, that our engineers had done that. If we did still have some type of irrigation, obviously the flow would be a little bit lower, so we could downsize that package area a little bit.
Okay, thank you so much. That is far less mysterious to me now, so I appreciate that. All right. You have also provided testimony that has indicated that perhaps you believe that the proposal the district has made to build connecting sewer and transport Hallsville waste is perhaps unrealistic, or I won't put words in your mouth, but anyway, you've questioned the viability of that option. And so it seemed that one of the reasons you were questioning it was the distance over which wastewater would have to be transported. And you pointed out in your testimony that it was 8 miles. Is there something about transporting wastewater over 8 miles that makes that especially expensive, onerous, impractical?
Our opinion is cost prohibitive compared to what we are looking at.
Okay, and so would your opinion about that be different if Missouri American had a treatment facility 8 miles away?
It depends on the infrastructure that you have set up, but not necessarily. We would be always looking for the most prudent option for our customers.
Okay. Is there a volume of wastewater that would justify that kind of transport arrangement?
I'm sure there is, but I would have to rely on my engineering staff to come up with that financial analysis.
Okay. All right, sir, I believe that those were all the questions that I had for you. And I'm going to check with commissioners and give commissioners another opportunity to speak up if they had any questions, and make sure I don't have any additional questions. Okay, it doesn't appear that there are any additional questions from the bench at this time. So we will open it up to recross and start with staff.
Thank you, Judge. Mr. Haran, I just wanted to make sure I heard you right. Did you say the city was going to change its base rates to $38?
$38.75. That is correct.
All right. And is it true that the current base rate is at around 19?
So the current base rate, it is $19.35 for the first 1,000 gallons of water consumed. And then every 1,000 gallons after that is an additional $5. So if they were an additional 4,000 gallons, it would be additional $20 on top of that, $19.35.
Okay. But now instead, we're just going to have the flat 38?
That is our intention, yes, sir.
All right. Thank you, sir.
Mm-hmm.
Okay, it appears that we're ready for recross from the district.
Thank you, Judge. Sir, did Missouri American do any analysis of the cost to transport wastewater flow from the Hallsville system to the district's Rocky Fork wastewater treatment facility?
We have not.
Nothing further, Judge.
Okay, thank you very much. Missouri American, did you want to engage in any redirect?
Yes, Your Honor.
Feel free to get started. Thank you.
Thank you. Mr. Haran, at the end of your initial cross-examination by Ms. Griffin, you were asked whether Missouri American intended to involve the district in any of its planning process. Do you remember that?
I do.
And I believe you said at that time, correct?
I missed that. I am sorry.
Did you answer no to that question?
I believe so, yes.
In your experience, does Missouri American's approach change sometimes based upon circumstances in the future?
Occasionally it can, if circumstances change.
Yeah. So your answer was based on what you know today, correct?
Yes.
But unknown circumstances in the future might lead to a different answer.
I would say that's accurate.
You were asked a question about why you testified that Missouri American could provide service in Hallsville at a lower rate than Hallsville could provide it itself, correct?
I was.
And I believe you mentioned the impact of the greater customer base, correct?
I did.
Would there also be economies of scale in regard to costs of materials, labor, engineering, that sort of thing?
There would. We do have national contracts for different types of materials that we are able to leverage our purchasing power nationwide to get better rates on different materials.
And then I assume you have engineering in-house as well?
We do have engineering staff in-house.
if you know, there was a discussion of the Sunny Slope and was it Silver Creek? The other subdivision, the two subdivisions that are served by the district, but the waste is treated by Hallsville. Do you know approximately how many customers are in those subdivisions today?
So it's been disputed, I think, back and forth in testimony. My understanding was it was a minimal number, something in the range of just a couple of residents, but I know the district had said that that was incorrect, so I'm a little confused on that. I know the mayor has a similar understanding that I do.
Okay. But ultimately, I think your testimony was that it would be Missouri American's intention, if it purchases Hallsville's system, to continue to provide the treatment of the waste from those subdivisions.
That is correct.
Okay. That's all the questions I have, Your Honor.
Okay, thank you very much. Before we take a short break, I'm going to ask if there are any additional questions for Mr. Haran at all. Okay, Mr. Haran, can you tell us if, the current rates under the application that the commission received indicated the city is charging a current rate of $19.35 and then an additional amount that is apparently based on water consumption. So is the company willing to have a certificate granted on those terms, that those would be the rates until an actual rate proceeding?
So I don't think that we're not saying that that would blow up the granting of the CCN or anything. I think we'll go with what the commission does, but our intention and our recommendation was the 38.75 flat.
Okay. And was there anyone, perhaps staff or district, did you want to ask any additional questions on cross, since I just introduced a new question? No? Mr. Pringle.
Yeah, Judge, Mr. Haran, when did the company make a decision about the 38.75?
It's been a little bit. I don't know the exact date or anything like that, Mr. Pringle. I did notice when I was reviewing some of the stuff with the older rates in there from Hallsville, and brought it to the attention of my counsel.
Okay. But yeah, just wanted to make sure, because I know in the staff rec we had that 19.5 number, so just wanted to confirm if we can get out where the 38.75 came from. But thank you, Mr. Haran.
Sure. No problem.
Any questions from the district?
No, Judge, thank you.
And Mr. Cooper, did you have any follow-up questions for Mr. Haran?
I do, just briefly, Judge. Mr. Hand, just so that it's clear, I think what you said in response to the judge's question is that if the commission decides that to grant the CCN, but call for the combination fixed rate and volumetric rate that was reflected in the application, Missouri American, that would not stop Missouri American from moving forward with the transaction, correct?
That is correct. We would honor it.
And if you know, when the public hearings were conducted in Hallsville, what rate was utilized in those presentations?
So from the literature that I have seen, it has always been 38.75 to the public.
And then one more question, if you know, in terms of total revenue to the company, is the 38.75 fixed rate the rough equivalent to the, 1975 plus the volumetric rate, just computed in a different way on an individual customer basis?
They're similar. Like for a $5,000 or a 5,000 gallon average customer usage, I believe it's slightly less than what the city is currently charging.
But in terms of the overall revenues to be received by the company, once you consider all the customers, are they roughly equivalent to Missouri American?
That's my understanding.
Yeah. That's all the questions I had. Good.
Okay, it appears we've now opened up an issue about what rate was proposed to the Hallsville public. And there is a document that was offered as an attachment to a district filing on December 14th, which appears to be an offer to Hallsville from Missouri American. And that document appears to identify a proposed rate. So is it possible for Mr. Haran to access that filing at this time?
Which filing was it, Judge?
It was filed on December 14th, 2020, in this case, by the district, and it is attached as Appendix A.
I'll have to pull that up, Judge.
Okay. So I will be patient while everyone locates this document. If once you've located it, if you could just let me know each party, and then we'll know when we can proceed.
I have located it, Judge.
So I think Mr. Haran has indicated he has found it.
I have as well, Judge.
I have two.
I have it, Judge.
And I'm sorry, Mr. Cooper, I wasn't looking at my screen, so I don't know if I've heard from you yet.
Yes, I have found it.
Okay, I apologize. There's a lot of voices. It's hard to keep them straight. So I think I've heard from all parties that this document has been found, and it appears that Mr. Haran has it and can review it. So I believe it would be useful, especially in talking to Mayor Carter about the proposal to the city and what current rates are and a plan to change the city's rates if that's currently what is underway, to be able to refer to this document. Mr. Haran, can you tell us if you recognize this document?
I have seen it before, yes.
Okay. And have you been able to locate where it discusses the proposed rate?
I have.
Okay, is that page 5?
Yes, it is.
Okay, and could you just tell us what that proposal is in regard to the rate?
So the proposal from Missouri American Water in there here is $38.75 flat rate.
Do you have any insight into why the current rate for Hallsville is indicated at $40?
I do not. I would have to probably do some quick math on it.
Okay. It looks like it indicates a typical residential bill of wastewater or water use of 5,000 gallons. So all you mathematicians out there, perhaps that provides our explanation. So I would propose, I'm sorry, go ahead.
No, I'm sorry, Judge. I'll let you finish.
I would propose that this document would be useful to the commission in understanding this case. And so I would propose that this document be admitted into the record as Commission Exhibit 305. Does anyone have an objection? I will note that it was attached as a public document, and so it has been out there as a public document, despite the fact that it's indicated on top that it's confidential. Are there any continuing concerns about the confidentiality of anything in this document? Okay, I imagine that ship has sailed at this point. So this, which I will characterize as a proposal offer, will be admitted to the record as Commission's Exhibit 305. And once again, once all the exhibits are filed, everyone will have an opportunity to make any corrections if the wrong documents get filed. Okay, so we've now gone into the question of what the proposed rate would be in Hallsville. And I'm going to once again give all the parties a chance to clarify any issues before we move on from Mr. Horan's testimony today. So once again, I will start with staff. Did you have anything?
Mr. Horan, I think you stated earlier that this 38 rate is cheaper than the current rate chart by the city of Hallsville.
For a typical 5,000 gallon user, that is correct.
Okay. Thank you, sir. I have nothing further, Judge.
Thank you. And anything from the district?
No, Judge.
Thank you. And Mr. Cooper, was there any final issues you wanted to clarify with Mr. Horan?
Just one thing. I'm going to follow up on your invitation to do some math here. Mr. Horan, if you take the 1975?
I want to say it was 1935, but I would have to go get the city's rates.
Yeah. But ultimately, that $40 appears to be just a slight rounding from the fact that you're taking into account the base charge plus the additional 4,000 gallons of volumetric usage, correct?
Correct.
Okay. That's all the questions I have, Your Honor.
Okay, thank you very much. All right, so we are going to take a short break. I would suggest that we get back together at 10 a.m., so it will be a short break. Does that work for everyone? Okay, we will be in recess until 10 a.m. and we will get back together and start with Mr. Carter's testimony. Thank you all so much.
Mr. Pringle, this is a court reporter. Are you back on the line by any chance?
Ms. Banks, is everything going okay?
Yes, I just wanted to know a word in his opening statement. Did he say Coke?
Oh, is that addressed to me, ma'am?
Mr. Pringle,
Yes.
in your statement you quoted at the nearly end, did you say Coke?
At the end, what? I got my opening in front of me. What was the words around we're trying to figure out?
It's hard for me to write and dictate at the same time. When you were talking about intercom and a quote at the very end, I thought you said
Yeah, the
Coke?
intercon gas, yeah. I quoted from them, and then I had an end quote after I finished the quote.
Okay, what was the end quote? Who
That would have
quoted it?
come right after. It is, if it is of sufficient importance to warrant the expense of making it, is a public necessity, end quote. That was from Missouri Coach Lines.
Missouri, that's what I'm saying. Missouri what?
Oh, Missouri Coach, COACH.
Okay, thank you. I couldn't hear that. That's all I needed. Thank you.
All right, no problem.
Okay, it is now 10 a.m. and it looks like we are getting most of our essential folks reconnected. I know that was a really short break. I'll try to make the future breaks a little bit longer than that one. And we are ready to get back underway and back on the record here today as we resume our hearing in SA 2021-0017. I believe where we are now is to take the testimony of Mr. Logan Carter, unless any party has anything that they would like to discuss before we get to that. Okay. And it looks like I'm seeing a warning sign on Mr. Carter's connection that indicates low bandwidth. Mr. Carter, are you able to hear us?
Yes, Judge, I am.
Okay, and so it looks like because of low bandwidth, you are not able to use video, or are you going to give it a try?
I do have it on. I don't see any indication of low bandwidth on my end.
Okay, and you actually sound and look good, so I think it's probably fine. Okay, so sir, if you could just raise your right hand. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do, Judge.
Thank you very much. Mr. Cooper, you may proceed.
Thank you, Judge. Will you go ahead and state your full name for us?
Logan Patrick Carter.
And are you testifying today in your capacity as mayor of the city of Hallsville?
Yes, sir, I am.
Have you caused to be prepared for the purposes of this proceeding certain direct testimony in question and answer form?
Yes, I have.
And is it your understanding that that testimony has been marked as Exhibit 2 for identification?
That is my understanding.
And I assume you do not have any changes that need to be made to that testimony?
I do not.
If I ask you the questions which are contained in Exhibit 2 today, would your answers be the same?
Yes, sir, they would.
Are those answers true and correct to the best of your information, knowledge, and belief?
Yes, sir.
Judge, I would offer Exhibit 2 into evidence and tender the witness for cross-examination.
Are there any objections to admitting Missouri Americans Exhibit 2 into evidence? Hearing no objections, Exhibit 2 will be admitted. I don't know if this is causing any problems for our court reporter, but it doesn't sound like our connection is as good as it could be. I'm going to mute your line, Mr. Cooper, as we might be getting a little bit of echo. Thank you very much. Okay, so we can proceed to cross-examination from staff now.
Yeah, thank you, Judge. Good morning, Mayor Carter.
Good morning, sir.
Now, why did the city of Hallsville decide to sell its sewer system?
The main reason being for us to continue to maintain and make the upgrades and repairs needed to our system, it would prove too costly to our citizens.
And in order to sell the city system, what kind of process did the city have to follow?
First, we had to have a public meeting 30 days prior. We had to pass an ordinance to have an election, have a public hearing 30 days prior to the election, and then hold an election.
And were you at that public meeting?
The public meeting held by the city of Hallsville, yes, I was.
And who attended that public meeting?
I don't have the official minutes in front of me of that meeting.
I guess was Missouri American Water in attendance?
I believe they were, yes.
And you were what were any representatives from the district in attendance?
I believe Mr. Ratterman was as well.
And did Missouri American Water speak or answer questions?
I can't remember off the top of my head on that meeting if either the district or company, Missouri American, had opportunity to speak.
Are you aware, were there any other meetings that either party had an opportunity to speak at to the public?
I know Missouri American Water held 2 public meetings at our community center.
And are you aware if the district held any public meetings?
I'm not aware if they had any or not.
And then, were there any other bids besides the bid from Missouri American Water?
Boone County Regional Sewer District and Liberty Utilities also submitted.
And why did the city choose the Missouri American Water bid over both Liberty and the district?
I can't speak for my alderman, but the general consensus is it was the best proposal for the city of Hallsville.
Does the city have a plan for what to do should the commission deny Missouri American Water's application for a CCN?
So we're starting to work on that. Number one being our rate increase to begin to have funds to begin the maintenance issues. But as far as treatment moving forward and our growth, no, there is not.
And is that rate increase, is that the $38 flat fee?
Yes, it is bill number 2021-2 to be known as ordinance 384. It would be raising our residential rates to a 38.75 flat rate, our commercial rate to 43.75 flat rate, and then a high commercial rate, which is 12,500 gallons or more, to 164.75 flat rate.
And is that rate cheaper or more expensive than the current rates charged by the city?
Well, our current base rate is $19.35 plus $5 per 1,000 gallons past the first 1,000. It would be a reduction for just over 50% of our customers.
And when is that ordinance also going to require a public vote?
No, that does not require a public vote. The bill has been read first and second time and is set to be voted to become ordinance on April 12th.
Thank you, Mayor Carter. And as part of the city's initial planning to what to do if the commission were to deny the CCN, does the city have any plans to sell to the district if that CCN were to be denied?
That would be up to a vote of my alderman. But at this time, I do not see that happening, no.
Thank you, Mayor. I have no further questions.
Thank you.
Thank you. We can proceed to any cross-examination from the district.
I don't have any cross-examination, Judge.
Okay, thank you. We would now take any questions from commissioners, if there are any, and I do have some questions that I would like to ask the mayor. And I invite commissioners to interrupt me at any point if you have questions that you would like to ask.
I believe we
So,
sent a question in, Judge. So I'm good just having you ask that question.
okay, thank you very much, Commissioner Holzman, and I am aware of that. Thank you. Did I have any other questions that commissioners wanted to ask at this time?
Not at this time, Judge. Thank you.
Thank you so much. Okay, so I just wanted to ask just a few basic kind of background questions, Mr. Carter. So first of all, when were you first elected mayor of Hallsville?
I was elected April of 2018.
Okay. And did you serve as an alderman before your election as mayor?
No, ma'am, I did not.
Okay. And can you just tell us a little bit about the governing structure of the city? How many aldermen are there?
We have 2 wards with 2 aldermen representing each ward.
Okay, so you have 4 aldermen and a mayor.
That is correct.
Okay. And when you all vote on something, it's one person, one vote.
That is correct.
Okay. And could you just remind us, how big is Hallsville? Do you know the population?
On the latest census, I do not. We're approaching 2,000 quickly. Just waiting for that official census to come out.
Okay. And as mayor, what level of involvement do you have with the city's sewer system?
I am in no means a wastewater expert. We have our director of public works for that, but being overseeing the board of aldermen, financial decisions moving forward with it would be on us.
Okay. And there has been some discussion this morning about the rates that Hallsville has charged in the past, and apparently now there's a proposal to increase those rates. You noted that you said over 50% apparently of your residential customers of the system, this rate change would actually reduce their rates?
Yes, as more than 50% of our residential use more than 5,000 gallons a month. So it would be a rate decrease for those.
So for that proportion of the people served, it's going to be a rate decrease, and for the rest of them, it's a rate increase.
It would be a rate increase, yes.
Okay, because the reason that the city would be proposing this is to bring in more money for the system?
That is correct. We run a very tight budget, and if this was to not go through, we need to begin forward thinking of having the revenue to do the projects needed.
Okay, and could you just restate for us, because some of the testimony we've heard so far has been that Mr. Horan wasn't able to maybe exactly remember what the current rate is in Hallsville. So are you able to tell us exactly what the current rate is in Hallsville today?
Current rate is $19.35 for the first 1,000 gallons as our base rate. For each additional 1,000 gallons beyond that, it is charged $5.
And it's $5 for each 1,000 additional gallons of water usage?
Correct.
And I don't know much about water and sewer, but I'm pretty sure you're not actually metering sewer. So that 1,000 gallons is water usage.
Correct.
Okay. And could you explain to us how Hallsville comes up with that water usage number?
We meter water.
Okay.
Address it, and then the customers that we do not serve, the water is metered by Public Water Service District number 4.
Okay, and that's Boone County Public Water Sewer District number 4, is that right?
Public Water Service District.
Public Water Service District number 4 of Boone County?
Yes.
Okay. And so you have a proportion of folks in Hallsville that get water from the Public Water District, and then you have some that get water from the city.
Correct.
And I believe that sewer rates are based on water usage during a certain period of the year. Is that right?
That is correct. We average the months of January, February, and March.
Okay, so it's January, February, and March inclusive.
Correct. Those months averaged.
Okay, and then that is going to determine a person's sewer flat rate for the whole year.
Sewer rate for the year, correct.
Okay, and then for some folks, you have to go to the public water district and ask how much water is that customer using, so we know what to charge them for sewer. Is that right?
They provide those numbers for us.
Okay. And thank you for your patience as I go through my list of questions and see what I've already asked.
That's perfect.
Okay. So we heard, we have received testimony from Mr. Horan, and part of his testimony includes the statement that the main holding lagoon for the Hallsville system discharged continuously for most of 2020, and that was in violation of Hallsville's permit. Is that accurate, sir?
It would have to be confirmed with my director of public works on the exact time, but we were in discharge in 2020.
And can you tell us more about what it means to be under enforcement by DNR?
So that's briefly where I have a little bit of a different understanding than everyone else. Under enforcement, we have a consent judgment from April 15th of 2013, which we have met those conditions, and under the judgment, we are allowed to ask the court to release us of that, but we are under advisement of a previous city attorney to not do that.
Okay.
And that was before my time here in the city of Hallsville.
Okay. So Mr. Horan's testimony also included a list of recent enforcement issues with the Hallsville system. His testimony includes the statement that the system was cited because only one of 2 aerators in the primary lagoon were functioning. Is that correct?
That could be correct, yes.
Okay. And that the system was also cited for failing to submit a complete annual operations report as required by its permit. Is that accurate?
I'm not aware of that.
Okay. And there was also a problem with failing to lower lagoon and storage basins to minimum operating levels from September to November as required under a condition of the operating permit. Is that correct?
That is correct.
Okay. So what is your understanding of the current enforcement status of the system in relation to DNR?
My understanding is DNR continues to watch us and look over us with a bit more of a microscope than others. But I believe that we overall are in good standing with the progress we've made.
Okay, are you familiar with the ordinance that was passed by the Hallsville Aldermen in August of 2019 concerning the sale of the sewer system?
Yes, I am.
Okay, and that was attached to Mr. Horan's testimony. I believe it was attached to Schedule MH1. So I just wanted to ask you a few questions about that. Do you have access to it, or if you needed to look at it, would you be able to?
I should be able to pull it up, yes.
Okay. Was the purpose of that ordinance to ask voters to authorize a sale specifically to Missouri American?
That's how it was approved by our then city attorney.
Okay. So I noticed that the title of the ordinance includes and identifies Missouri American. Are you able to read the title of that ordinance?
An ordinance calling for an election in the city of Hallsville. Missouri, to be held on November 5th, 2019, for the purpose of submitting to qualified voters of the city a proposition to sell certain assets associated with the city's wastewater system to Missouri American Water.
Okay, thank you. And part of an aspect of that ordinance, after it describes the proposition to be put to voters on the ballot, also includes authority to the city to negotiate a sale. Is that right?
Yes, it did.
Okay. So if Hallsville's alderman decided, and we're just going to assume that Hallsville would be able to do this. If Hallsville decided it wanted to sell the system to a different entity, is it your understanding that Hallsville would have to propose another proposition to its voters?
That is not my understanding, as the ballot language did not include Missouri American Water. The ballot language was simply, shall Hallsville sell the wastewater system?
So your understanding is that the voters of Hallsville have now given the alderman the authority to sell the system?
Yes, ma'am.
Okay. And that's even though the ordinance itself specifically authorized the alderman to negotiate with Missouri American to sell the system?
That was my understanding, yes.
Okay. All right. And then there is a document that was filed in this case for 14th as an attachment and has been admitted as Commission's Exhibit 305. Were you able to locate that document, or did you look for it when we were looking for it earlier in the hearing?
I did look for it, but I was unable to find it. Could you share again who filed or what exhibit it is?
Yes. Okay. So you will find this document in the EFIS record for this case. Are you accessing the Commission's record of this case?
I'm looking at for it now.
Or potentially counsel might be able to provide it.
Yeah, Judge, if you give me just a second, I'll get it to the mayor here.
Thank you.
Mayor, I just hit send, so let me know if it gets to your email there. And again, Judge, this is the document you marked as Exhibit 305.
That's correct. On the top, it says Better City of Hallsville.
Okay.
I have pulled up that document.
Okay, thank you. So if you can take a look at that, I wanted to ask you, first of all, do you recognize this document?
Yes, I've seen this document.
Okay. And it appears that it's dated July 18th, 2019. Is that right?
Yeah.
Okay. So I wanted to ask you about the timeline for the events that took place. So it would appear that this document comes into the city in July of 2019. And then, as you have described to us, in August of 2019, the city passed an ordinance which we have been discussing that authorized the sale. Is that correct?
Correct.
Okay, and I believe that that's what's indicated by your testimony on page 4. So then after that ordinance is passed, the city also put out a document that is a request for bids. Is that And that document is actually attached to some rebuttal testimony from the district. So that hasn't been admitted into evidence or offered yet, but this would be attached to Mr. Stith's rebuttal testimony as Schedule DES 2. So according to the dates on those documents, the city put out the request for bids in September 2019. Is that
Yes,
right?
our city attorney felt that we should also request open for bids and not focus on one potential buyer.
Okay, so the city hadn't solicited bids when it received this offer from
Correct.
Missouri
I had
American?
met with them and discussed the possibility with our board over the months prior to that.
Okay. And I'm clarifying this just because I wanted to make sure the timeline was accurate or some dates hadn't gotten mixed up somewhere. All right, and then we're in September when the request for bids goes out to for the city soliciting bids, but the city has already authorized this proposition to go to voters in November of 2019.
Correct.
Right. And we have heard some testimony, hearings, or maybe the term would be meetings that were held in Hallsville regarding the acquisition potentially of this sewer system. And I just want to clarify, there were 3 different meetings held, is that right?
The city of Hallsville held one on October 3rd of 2019.
Okay. And then I believe your testimony, or I'm sorry, Mr. Haran's testimony provides the dates for 2 other hearings. So you are aware of 2 additional hearings that were conducted by Missouri American?
That is correct.
Okay. And then the next thing that happens is after those meetings are held in October, then we get to the election on November 5th, 2019. And there was some discussion earlier today about whether we actually have any information in the record regarding the actual vote in that election.
So the certified votes from Boone County Clerk was in the question of the city of Hallsville on the November 5th, 2019 election. Yes was 136 to no 64.
Okay. And did you consult something today to get those numbers, or are you aware that they appear anywhere in this case file?
I'm not aware of them being in the case file. I pulled those numbers from our county clerk's results.
Okay. Okay. So did you just go to the Boone County Clerk website today, or did you have them
I have that
sitting
as well.
somewhere?
Here, a document with me.
Okay.
I thought it might come into question.
All right. So I'm sorry.
I thought
I
it might
apologize.
come
Please
into
finish.
question, so I wanted to have it to be prepared.
Thank you. I appreciate that. That does answer a question that we have had today. Okay. All right. And then after this vote occurs and the majority of voters approved the sale, then it appears that other bidders had made a proposal to buy the city, or I'm sorry, to buy the system from the city. Is that right?
Yes. So our RFPs were due on November the 1st. November the 5th, the election passed. And then November 20th, we had a board meeting to discuss the next steps to take in the wastewater sale, which Missouri American, Liberty Utilities, and Boone County Regional Sewer District had representatives at, and discussed our next steps there.
Okay. And was there a session in January of 2020 concerning the sale of the system?
Yes, we had January 22nd. We had a board meeting in which all 3 parties, Missouri American Water, Liberty Utilities, and Boone County Regional, were able to present their offers.
Okay. And I wanted to clarify something about your testimony there, because I believe your testimony was that Missouri American, the district, and Liberty Utilities, quote, were given the opportunity to present their proposals. And I wanted to clarify, did those entities all show up and present
Yes,
their
they were.
proposals on
Yes,
January
in person.
22nd? Okay. And what was the purpose of that session if the sale had already been approved?
From our understanding, the voters had voted that we were allowed to sell our sewer system, and we wanted to do what was best by our voters and hear out all parties of their offers.
Okay. And we went to pains today to make sure that you could take a look at that proposal offer to the city of
Yes.
Hallsville. And I wanted to look at the rate where the rates are discussed on page 5. Can you find that?
Yes, I'm there, Judge.
Okay, thank you. Okay, thank you. So can you just explain to us how your understanding of the proposal for a flat rate and how that related to what the city had been charging and what Missouri American was proposing here?
I don't think I can speak to their thought process behind their rate, other than knowing that it was the rate that they charge small municipalities outside of Arnold, Missouri.
Okay, and was this, I guess a better question would be, this proposal to charge Hallsville customers $38.75 as a flat rate, was that presented to the city and in these meetings before the board and also at public meetings that the city hosted?
It was presented to the city and presented to the public through Missouri American Water's meetings.
Okay. And I'm asking that question because the company's application to the commission actually refers to Hallsville's existing rates. But this proposal document to Hallsville references a different rate. And so I'm trying to understand if this document represents what was presented to Hallsville, or if the presentation was in fact that Missouri American was going to adopt Hallsville's existing rates.
No, there was no presentation to the city of Hallsville that they would use our current rate structure. All along, they've been at a 38.75 as presented to the public in the city.
Okay. All right. And then I wanted to ask you about the document attached as Schedule MH2 to Mr. Horan's testimony. This, I believe, is the purchase agreement. Are you able to access that document, or can Mr. Cooper provide that to you?
I'm seeing if I can get through on the EFIS.
Right. So it'll be Mr. Horan's direct testimony on January 26th.
And you said it was MH4?
It's actually, I believe it's MH2.
Okay.
And it's not a separate file. It's part of the base testimony.
Okay.
If I can provide you a page number, I will. I believe it's page, getting there. I believe it's page 15 on, according to my PDF program, is the beginning of that document.
Yes, I'm there, Judge.
Okay, so is this the purchase agreement that was signed by Missouri American and Hallsville?
Just going through it to confirm, but yes, it is.
And I believe that you are a signatory to this document. Is that right?
Trying to get to the end of the to confirm, but yes, I am.
Okay, thank you. All right, and then I also wanted to ask you about the cities entering into agreements with the district to provide sewer services to some district customers in certain subdivisions.
Yes.
Okay, and this concerns a couple documents that were previously attached in some filings in this case and have now been made exhibits. And I'm not sure if you'll need assistance from Mr. Cooper to access these or if you can get to them directly yourself. But these were marked as Commission's Exhibit 303 and 304. And they are found in the August 31st filing made by the company, Missouri American. They are Appendix E and Appendix F to that pleading.
You said it was the August.
It's August 31st.
Judge, I also just sent send on that if that happens to get to the mayor before he finds it the other direction.
Thank you for your help. I apologize for some of the tedium here.
You're fine. I'm here at Appendix E and did you say E and F?
Yes. Yes. So there should be one right after it that we'll be talking about. So let's start with the documents that is marked Appendix E. On the top, it says Bill number 2019-4. Can you tell us what that ordinance number is?
358.
Okay. And are you a signatory to this document, sir?
Yes, Judge.
Okay. And what does this document do?
This would allow the mayor to execute a cooperative agreement with Boone County Regional Sewer District in regards to let's see which one this one is. The Sunny Slope subdivision.
Okay. And so then following that document, is there a cooperative agreement that's dated January 14th, 2019?
Yes, there is.
And that concerns the Sunny Slope subdivision?
Correct.
All right. And what can you tell us about this agreement? What was the purpose?
From my understanding, the Sunny Slope system needed some updating and to get rid of the lagoon that is currently on that property just outside of the city. And there would be a time frame in which Boone County would do upgrades to the lines in that neighborhood and to connect to us and fill in that lagoon.
Okay. And why was the city interested in entering into this agreement?
Being a good neighbor.
Okay. So it's providing, I suppose, some assistance to residents?
They're just outside of our city limits.
Okay.
And to my knowledge, that subdivision has not been yet.
So is this a new development?
No, it's not.
Okay, so it's an existing residential development.
Correct,
okay.
Outside of the city.
And I have been trying to figure out how many lots are here that are potentially affected by this Sunny Slope agreement. Do you know the answer to that question?
I believe off the top of my head, I'm going to say there's 11 customers. You would have to confirm that with the district as they're currently their customers.
Okay. And I believe there's a map that's attached as an Exhibit A to that cooperative agreement. Did you find that?
Yes.
Okay. Does that depict the number of lots?
That would.
Okay.
The larger lot, I believe, is where their lagoon is on that property.
Okay. Are there, you said this was an existing development, so are these occupied lots with people living on these lots and houses requiring sewer service?
I can't confirm that every lot has a house on it, but it wasn't existing structures and there.
Okay, so is it a maximum of about 11 lots that would be residential?
It looks there could be 14 to 15. Again, this is outside of our city limits, so
Okay.
I don't know the exact number.
And did this agreement require the district to make any lump sum payments to the city to make this agreement work?
No, I do not believe there was a lump sum payment.
Okay.
Trying.
Do you know, can you look at paragraph 10 and tell me what the purpose of that was?
I do take that back. There was a one-time payment.
And do you know if the amount of that payment?
It looks like it says $5,100 to cover costs of capacity.
And then could you read the sentence after that? It may answer some of our questions.
This charge represents a $300 per unit fee of 17 units.
Okay, so that might tell us how many possible units there are expected in this or exist in the subdivision.
Correct.
Okay. Do you know if any payments have been made under this agreement?
I do not recall.
And I may have asked this and you may have been asked this, but I just want to make sure. Do you know if the city is currently providing sewer service to any of the residents of Sunny Slope subdivision at this time?
My understanding is that the county regional sewer district has not connected Sunny Slope at this time.
Okay. All right, so we can proceed now to what has been marked Commission's Exhibit 304, which I believe starts on page 20, and it looks like it's bill number 209-8. Did you find that, sir?
I'm scrolling down now. Yes, I'm there. Ordinance 362.
Okay, thank you. And you're a signatory to this document, sir? Okay, and what does this document do?
This document gives me the authorization to execute an agreement for the Silver Creek subdivision cooperative agreement with Boone County Regional Sewer District.
Okay, and does the cooperative agreement appear on the next page?
It does, dated April 8th.
And I'm sorry, repeat the date, please,
April
sir.
8th, 2019.
Thank you. And this agreement looks like it's slightly different because it involves and mentions a developer in addition to the district and the city?
Correct. This piece of land, I believe there is currently only one home on it, and then he was going to develop another 6 lots for a total of 7.
Okay, and can you tell us what the purpose for the city was of entering into this agreement?
Again, to assist Boone County Regional Sewer District with providing treatment to their customers.
And does this agreement call for a lump sum payment of any kind?
I believe there was. I'm going back through.
I think paragraph 10 might help you.
Yes. The amount of said payment shall be $4,200, represents a one-time connection charge. This charge represents $600 per unit fee for 7 units.
Okay, and do you know if that fee, lump sum fee, or any fee has been paid under this agreement?
I would have to look back at records to see.
Okay, do you know if anyone is receiving service in I believe this is the Silver Creek subdivision, is that right? That this pertains to?
Yes, there are residents our individuals receiving service in Silver
Do you
Creek.
know how many lots are receiving service from the Hallsville sewer system?
I believe that number's 3 in that neighborhood.
Okay. And once again, these are lots that are outside the city limits
Correct.
and they are district customers?
Correct.
Okay. This cooperative agreement also appears to have a map attached to it.
Yes, Judge.
Okay. So it looks like your testimony today is about 3 lots in the Silver Creek subdivision are currently receiving service from the city of Hallsville sewer system. And you weren't sure if any of the Sunny Slope lots are receiving service at this time.
Correct. From my understanding, Sunny Slope has not been connected to our system.
Okay. So I asked several questions about these 2 agreements. Is there anything else that you would tell me about those agreements or you think the commission should understand?
No, I believe they're thorough. It was us doing our part to be a good neighbor to the district.
And that reminds me of actually another question I wanted to ask about both of these agreements. Do you happen to recall the term under each agreement, how long these were supposed to be in place?
I do not recall off the top of my head. I can view them in the document.
Okay. It looks like paragraph 16 might have that information in it.
The initial term shall be 20 years beginning on the date first shown on this agreement. Thereafter, this agreement shall automatically be renewed for a term of 5 years unless it is terminated pursuant to the provisions of this paragraph.
Okay. And does it appear that that's the same provision in both agreements, essentially?
Yes, it does.
Okay. Okay. Have there been any efforts by the city to annex either I want to say Silver Creek, but I might be making that up. It could be Silver Star.
Silver Creek
and Sunny Slope. Has the city made any efforts to annex those?
Silver Creek is not contiguous with our border, so we were unable to annex that property.
Okay.
With Sunny Slope, a forced annexation is never a good thing. It would be up to the residents to willingly annex, and we've not proceeded with anything of that nature.
Okay, so there's no pending issue of annexation. Okay, thank you. Okay, so those were the questions from the bench at this point. Once again, if commissioners have any questions that they wanted to ask of the mayor, the floor is open for those now. Okay, we can proceed then to recross, and we may always be interrupted by commissioners if they so desire. Please proceed, staff.
No recross, Judge. Thank you.
Thank you. And anything from the district?
No, Judge, thank you.
And did Mr. Cooper, did you have any redirect?
Yes, Your Honor. Briefly.
Thank you. Please proceed.
Mayor, you provided a couple times information related to, or you mentioned the city attorney that was advising Hallsville during the course of this sort of election and RFP process. Do you remember that?
Yes, sir.
Who was that attorney?
City attorney at the time was John Whiteside.
Is it your understanding that Mr. Whiteside has also represented at times the Boone County Regional Sewer District?
My understanding is John Whiteside is the general counsel for Boone County Regional Sewer District.
You had mentioned in regard to a question that, in your opinion, a sale to a different entity other than Missouri American would not require a separate vote of the public, correct?
That's correct.
And I assume you don't offer that opinion as an attorney, but just as your own personal understanding, correct?
That is how it was presented from our then city attorney, John Whiteside.
And again, the city currently has no contract to sell its sewer system to the district, does it?
There is no such contract to sell to the district.
You were asked what the city would do if Missouri American did not purchase the sewer system, the Hallsville sewer system. Am I correct that you said that the city really doesn't have a plan for how it would address the treatment issues in that circumstance?
That's correct. Not at this time.
And I assume you also would not have a plan for how to address any financing that would be necessary to address those problems. Is that correct?
Not at this time, sir.
Well, that's all the questions I have, Your Honor.
Thanks. I have a wandering mouse and I couldn't find my mute button. All right, so I did want to ask if perhaps it would be possible for Missouri American to provide from Mr. Carter whatever certified document or copy of certified document from the Boone County Clerk's office, or perhaps it's Boone County elections, in regard to that November 5, 2019 election, so that we don't have to rely solely on statements in the transcript. Would it be possible for that document to be filed as a late filed exhibit by April 12th in this case?
Judge, we are certainly willing to do that. I'll have to get further into it before I know whether April 12th is a doable date, but certainly we will strive to do that.
Okay, so if April 12th doesn't work, then I would ask that you file something just letting us know what your timeline looks like. And then you could file it promptly as soon as it were possible. It sounds like Mr. Carter has some kind of document that he's been able to refer to.
Correct.
Does anyone have an objection to that document being admitted to the record? Obviously, once we actually see it, there will be an opportunity to object to the actual document itself once we've seen it.
No objection, Judge, but I do have, in the alternative, I have found an article from the Missourian that has those exact same numbers as well, in case a problem arises with the Boone County Clerk.
Thank you. I hope the Boone County Clerk can provide what is needed, and in the event that that isn't possible, then we'll rely on the good old Missourian. Okay? Thank you. All right, so I believe that was all the questions that anyone had for Mr. Carter. Before we move on, I would just give an opportunity for anything else that has come up. All right, so it appears then that we've heard from Missouri Americans' witnesses. We've talked about the possibility of this late filed exhibit to give us a document to refer to with the election results for the vote on the proposition to sell the Hallsville system. As I said before, I'll ask that Missouri American provide that. First, I should say thank you, Mayor Carter, for appearing today. And I'm asking witnesses to remain available during the hearing in case we have to recall you, but hopefully that won't be the case. So whatever document is filed by Missouri American to verify the results of that election, that would be Missouri Americans Exhibit 8. if I'm keeping track. Okay. So it looks like we can move on and get started with a staff witness before we go to lunch. Give me one moment to check my email and then we'll get right back to get started. Actually, this is what I'm going to propose. I'm going to take a quick recess until 11:15 to reorganize ourselves, and then we'll get started with staff's witnesses if that's okay with everyone. Okay, we are in recess until 11:15. Thank you so much. Okay, everyone, it appears we have everyone we need to get started again. We will go back on the record. This is the hearing in SA 2021-0017, and we are set to hear testimony from staff's witnesses, starting with Mr. Bush.
Judge, I think the court reporter was asking for 1 minute.
Okay, oh, you're right. Thank you. We can't get going without her, so we will wait until our court reporter's ready to go.
Judge, I have a couple things that, while we're waiting for that, if you have a minute. First, Mayor Carter has some childcare issues about 2:30 today. So if it would be okay, we would, if there are no questions, additional questions for him by then, we would like to ask that he be excused so that he could leave the hearing.
I understand, and we will strive to make sure that he can be excused by 2:30, and I appreciate you bringing that to my attention.
The other thing is I have emailed to you and the other council the document that the mayor was looking at when he was testifying earlier. I think it may satisfy your request, but when you have an opportunity, Judge, if you'd take a look at that and see if that will suffice, that would be great.
Okay, I haven't, oh, I just got it. And so when I have a chance to review, I will do that and we'll discuss that, but I'd like to get started with Mr. Bush. So hopefully we can wrap him up before my stomach starts growling.
Judge, I got disconnected, so that was off the record, correct?
Yes, this is all off the record. We are just doing some housekeeping while we patiently wait for you to get everything up and running again. Please let us know when you're ready.
I'm good. I'm just have to go by the computer now, so you'll see when I'm muted or not.
Okay.
Thank you.
All right, so are you ready to go? Okay, thank you. Now we are genuinely back on the record in this hearing. It's SA 2021-0017, and we will be getting started with staff's witnesses, and we will start with Mr. Bush. So, Mr. Bush, I can see you, sir. If you could speak to us now, and we'll make sure you have a good connection.
Morning, Judge.
Good morning. I can hear you. So if you want to raise your right hand, I'll get you sworn in. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you very much, sir. Mr. Pringle, you may proceed.
Thank you, Judge. Good morning, Mr. Bush.
Good morning, Mr. Pringle.
Please state and spell your name for the court reporter.
My name is James Bush, and Bush is spelled B-U-S-C-H.
And Mr. Bush, by whom are you employed and in what capacity?
I'm the regulatory manager of the Water and Sewer Department for the Missouri Public Service Commission.
And are you the same James Bush who contributed to staff's recommendation to grant CCN, marked here as Staff Exhibit 100?
I am.
And do you have any additions or corrections regarding corrected direct testimony of James Bush, Exhibit number 100?
I do not.
And if I were to ask you the questions contained in Exhibit number 100, would your answers be similar or substantially similar today as those contained herein?
They would.
Are those answers true and correct to the best of your knowledge and belief?
They are.
Thank you, Mr. Bush. At this time, staff moves to enter Staff Exhibit 100 into the record.
Okay, thank you. And just to make sure that we are very clear, we are talking about the corrected direct testimony of Mr. Bush, which Mr. Pringle circulated to all of the parties. That's been marked as staff that's been marked as staff's Exhibit 100. Does anyone have any objections to that being admitted to the record? Okay, hearing no objections, staff's 100 will be admitted to the record, and we can proceed to any cross-examination, starting with the company.
Thank you, Judge. Mr. Bush, would you describe the Hallsville sewer system to be a small system?
Yes, I would.
Would you consider it to be a troubled system given its environmental compliance issues?
I think it is fair to say that it has some environmental issues.
Now, you sponsor the staff's recommendation in this case that the MAWC application be approved, correct?
Correct.
In your role as a regulatory manager of the Commission's Water and Sewer Department, have you previously been involved with small water and sewer system acquisition cases?
Yes, I have.
Would you have a guess as to how many?
I've been the manager since February of 2008, so 13 years. Probably fair to say we do maybe 4 or 5 a year. So, you know, that's what, 13 years times 5, about maybe approximately 60, maybe more.
In your experience, does a feasibility study for a small water or sewer system that's being acquired generally show a positive income in early years?
Generally, they don't. It's my experience that most of our small systems, be they a regulated system or an unregulated system, the rates are generally not high enough or sufficient enough to allow for any sort of profit or positive income in the feasibility study.
And in that situation, is that lack of positive income likely to continue until a future rate case?
Yes. Yeah.
If you know, has Missouri American in the past been permitted to pursue rate cases on a system by system basis?
I am not familiar. I've worked with Missouri American rate cases since 2000, and I am not aware of any Missouri American rate case that was for a specific system. They were always for all the separate districts at the same time. And staff would very much frown upon Missouri American coming in for a individual system rate case.
So if Missouri American ultimately purchases and then makes improvements to the Hallsville system, would you agree that it will not be able to raise rates on that system on a system-specific basis?
They would have to come in for a general rate increase, which would include all the other service areas that Missouri American provides service to.
And in that general rate case, would it be true that any improvements to the Hallsville system would be examined for possible recovery to include the prudence of those improvements?
Yes, any improvements that are done by a utility regulated by the Public Service Commission, we review those for the prudency of those decisions.
Okay. That's all the questions I have at this time, Your Honor. Thank you.
Thank you. Do we have any questions from the district?
Yes, thank you, Judge. Mr. Bush, would you agree that the entirety of Hallsville's wastewater treatment system is located outside the city limits in unincorporated Booneville?
It's my understanding that the wastewater treatment facility is located outside the city limits of Hallsville and Boone County.
And would you agree that that is an unincorporated area of the county?
That would be my understanding.
And would you agree that so long as the city of Hallsville owns and operates its system, that system would be classified as a municipal sewer system?
Could you repeat that, please?
Sure. Would you agree that as long as the city owns and operates that system, that the system would be classified as a municipal sewer system?
My understanding would be a municipal system, yes.
Would you also agree that if Missouri American is authorized by this commission to consummate its purchase of the Hallsville wastewater system, the system will no longer be a municipal system following the consummation of that purchase?
The system will no longer be owned by a municipality. It will be owned by a private entity.
So would you agree that in that instance, it would no longer be classified as a municipal system?
I'm not exactly 100% sure where you get a classification as a municipal system. So not knowing exactly how that classification goes, but it would not be a municipal system owned by a municipal owner.
Okay, thank you. Nothing further.
Okay, the floor is now open for any questions from commissioners. I will have a few questions to ask, and then, of course, as I've said before, commissioners can always interrupt me. So I just had a question for you, Mr. Bush, just starting with the map that is attached to Mr. Horan's testimony, his direct testimony as Schedule MH3. I don't know if you're able to look at that.
I am looking for it now, Judge. You said MH3?
I believe it is MH3.
I am looking at it.
Okay. And my understanding from reading staff's recommendation was that staff was not satisfied with the map that was initially provided with Missouri American's application. Is that right?
I think that is correct.
Okay. And do you know if this map attached with Mr. Horan's testimony addresses all of staff's concerns about the depiction of the area to propose to be certificated, or any of the other concerns staff would have had?
I believe so, but staff expert Williams may be better to answer that question completely.
Okay, thank you. I would like to ask you about your understanding of a feasibility study, which is required to be provided with an application for a certificate. What is your understanding of whether a feasibility should or must include information about any improvements that a new operator might need or want to make to the system?
I am not familiar with that level of detail required in our feasibility studies.
Okay. We have heard some testimony today indicating that Missouri American has proposed to apply to the Hallsville system one of the flat rates that it has established under its tariffs. Staff's recommendation actually discusses the information provided in Missouri American's application, which restated the city's current rates for sewer service. Can you explain to the commission whether staff has any concerns about the disparity between what was stated in the application, the information that was provided in the feasibility study, and the testimony as far as apparently a proposal to increase Hallsville's rates to match a Missouri flat rate?
I don't believe that staff had any issue with the what was in the feasibility study and what was in the application. As has been mentioned before, the current rates for the city of Hallsville, as I understand them, and what the Missouri Americans' current tariff rates for a system that Hallsville would be a part of are very similar. It's slightly less. Missouri Americans' rates are slightly less. If a customer uses 5,000 gallons, it'll be slightly more if a customer uses 4,000 gallons. So, you know, it's probably it's a good approximation, but I think staff went ahead and recommended that the city of Hallsville's current rates continue. From my perspective, it's a new information that the city of Hallsville is proposing to increase its sewer rates to $38.75, and that may be the rate going forward. I don't think that I'm in a position right now today to speak on behalf of staff, because we have not had a chance as an entire staff to think through what we've heard today to make a good recommendation to the commission.
So I just want to clarify, so the commission understands exactly what the application included. Didn't Missouri Americans feasibility study in this case always include the 3875 figure?
The feasibility study did, but I believe their application stated that they were going to keep rates the same. My assumption would be, and staff expert Young, he reviewed the feasibility study, so he can correct me later if my understanding is wrong. But since it's a volumetric rate that is currently in effect for the city of Hallsville, for Missouri American to do a feasibility study, they'd have to come up with some level of monthly income. And so based upon what the current rates are for Hallsville, and like I said, if a customer uses 4,000 gallons, it's right around $34. If they use 5,000, it's around $39. So 38.75 was probably a good proxy as an average for all those customers for the feasibility study, instead of having different rates or different monthly rates for the citizens.
You may not know the answer to this question, but I'll ask. In your experience, have you seen applications where a company asks for a certificate and proposes to adopt the rates being used by the system at that time?
We see that. It really depends on each situation, and generally speaking, if the current rates that the existing system is charging its consumers is lower than the purchasing company's tariff rates, staff usually recommends that the rates do not change because of the acquisition.
So which rates don't change? The rates of the acquired system?
Right, the current rates. The customers, generally speaking, staff's philosophy has been that the rates to the current customers should not increase solely due to the fact that it's being purchased by another entity.
Okay. So proposing to acquire a system and keep rates stable for the customers of that system, that would be typical of an application.
It is, yeah, typical is probably a good word.
And in this case, what we've received now is testimony that the company is proposing to just adopt the rates whatever they are at the time the system is acquired, understanding that apparently there's a move to increasing rates. Does staff, in order to do its recommendation to commission, want an application to say exactly what rates are going to be if the certificate is granted?
I mean, staff, yeah, we need to see what the company's proposal is, but ultimately staff will review it. We'll review the current rates, we'll review the tariff rates, and then we'll make our recommendation based upon that.
Okay, and I have to go back and clarify something. In this case, the company said that we're going to adopt the systems rates that we would like to acquire, and these are the systems rates. And typically, just to make sure I understand your testimony, typically staff would recommend that the current rates be used rather than adopting the acquiring company's rate?
If those rates are below, yes. If the rates are above, then we would recommend going at the company's tariff rates. So a decrease.
Okay. I see. Okay. And is that a preference for a rate that has been set in a rate proceeding? Or is it just a preference to not approve an acquisition and have people's rates going up?
It's a preference to not see, for the customers not to see a rate increase.
Okay. All right, so I would like to ask you about one of the conditions that have been proposed by staff and staff's recommendation. And this condition concerns the effort to ensure service to the district customers in the Silver Creek and Sunny Slope subdivisions under the agreements with Hallsville. As I read staff's recommendation, the recommendation is to require the company, once it gets its operating permit from DNR, to initiate negotiations with the district to provide that service. And then when staff elaborates on the condition, the explanation seems to be that if those required negotiations don't result in an agreement, then that would be considered a violation of the certificate. So the question I have about that is, can you explain the purpose of this? Why wouldn't the requirement simply be to provide the service under the existing terms rather than telling folks that they need to negotiate?
Probably staff phrased it the way that we did because Missouri American had indicated, or we'd read where Missouri American indicated that they were not held to that agreement itself. And so we felt that since, Missouri American is not the city of Hallsville, that it would be better to have a new negotiated contract between the actual entity that is operating the system rather than just taking over a contract that may or may not prove unsuitable for Missouri American and the district.
And so then that's when I get around to asking what the intent was, because when it's explained as if the intent is to make sure that these customers in these two subdivisions continue to have service. And so if that's the purpose, can that result be reached by requiring negotiations?
We believe so, yes.
And can you explain to me why staff is concerned about making sure that those district customers still have sewer service available through Hallsville?
Well, we want to make sure that those consumers who are living in that area continue to receive service. Ultimately, if the district is capable of providing service to the customers themselves in a safe and adequate manner, I think staff would be comfortable with that as well. So we just want to make sure that as it sets up currently, that no customer will lose service simply because of this transaction.
Okay, so I think that the staff's recommendation provides that ensuring continued service for the customers in question is essential for the requested CCN to be necessary and convenient for the public service. So if the commission were to conclude that for whatever reason it doesn't want to condition a certificate on service to those customers, is staff recommending that the commission wouldn't be able to find that this certificate is necessary and convenient for the public service? Trying to figure out how essential this issue is under staff's recommendation.
And I apologize, Judge. There was a lot in that question. So I'm going to rephrase it to make sure I understand exactly what you're asking me. If the commission decides to approve the transaction and they want to exclude that recommendation, is that the first part of what you're asking?
Right, because it seems that the staff's recommendation seems to take the position that this is actually necessary for a necessary and convenient finding. So I'm trying to figure out if that's really what was intended there.
Well, that was our intent. If the commission decides that they want to not include one of those conditions, but they still find that it is in the public interest, that is the commission's decision.
Do you happen to have updated information about how many households are currently receiving service in those subdivisions from Hallsville?
I have no more information than what the mayor provided earlier today.
Okay. And then just one other question on this point. Is there a reason why staff recommends that those negotiations would have to start after a permit is issued by DNR?
I believe that we put that in there because if the DNR does not give them an operating permit, then there would be no need for Missouri American to have an agreement with the district.
Okay. Then I wanted to ask you a question about, just to make sure that we're all on the same page about the basic facts. It appears from previous testimony that some customers in Hallsville receive water service from the Public Water Supply District number 4. Is staff aware of that?
Don't know if the rest of staff is aware of it. I found that out today.
Okay, okay. And then, no, I think that those are all the questions that I had for you, Mr. Bush, and I appreciate your patience with me. I may have a couple more.
And if I may, Judge,
Yeah.
based upon that information and finding out that all the water is not provided by Hallsville, that may influence at least my recommendation to staff that going with a flat 3875 might be better because it may be more difficult for Missouri American to obtain the water readings from the water district.
Right. So as we developed before, Hallsville presently has to go to the Public Water Supply District and get that usage information. And so Missouri American would also have to do that if they wanted to use a volumetric system.
That is correct.
Okay. Okay. All right. And I just need to clarify this point for you, just to make sure it's clear. If the commission didn't require that service be provided to the residents of the Silver Creek and Sunny Slope subdivisions, would staff still support a commission order to grant a certificate on those terms?
It is staff's job to support all commission orders.
Would staff recommend that the commission grant a certificate if the certificate didn't include a condition that either required negotiation to ultimately provide service to residents of those two subdivisions, or required the company to comply with obligations under the current agreements on the same terms?
Well, that's a very difficult question, and it would be, I mean, it's staff's recommendation that that be included, and it would be my thought that that is a necessary condition. But since that is something that has just been posed to me, that's a pretty significant change that I think staff would really want to talk about internally.
And I apologize for having to just toss that at you today, and I appreciate you're doing your best with that. And hopefully with post-hearing briefing or further developments here, that can be clarified. Okay. Once again, the floor is open to any questions from the commission. And I will also ask for any recross at this time. Is there any recross from Missouri American?
No, Your Honor.
And does the district have any further questions for Mr. Bush?
No, Your Honor.
And Mr. Pringle, did you want an opportunity for redirect?
Yes, Judge, real quick. Mr. Bush, regarding the condition you were discussing with Judge Jacobs about from our recommendation, are those customers we discussed, are they customers of the city of Hallsville?
No, they are not.
Are they simply direct customers?
It's my understanding that they're customers of the district and that the city is providing a wholesale service.
Yeah. Thank you for correcting. I said direct, I meant districts. Thank you, sir. Nothing further.
Okay, thank you very much. I think that what we will do, and thank you, Mr. Bush, I have asked that all witnesses remain available during the hearing to the degree reasonably possible. If that's a problem for you today, please ask Mr. Pringle to let us know. So thank you for your testimony. You're excused at this time. It is 11:45, so rather than starting with another witness, I would propose that we would break for lunch until 1 o'clock. Does that work for everyone? Okay, so we will all reconvene at 1 o'clock and we will pick up at that time with Mr. Robertson. We are now in recess. I thank you all. Ms. Banks, I just want to confirm you have a good connection and everything is fine on your end.
Yes, I got through the phone again.
Okay. So you'll be ready to start at 1 o'clock?
Yes, ma'am.
Thank you. Okay, it is almost time to get started. We will get started at 1 o'clock. It appears that we have almost everybody we need. Okay, it is now 1 o'clock, and we will go back on the record in our hearing today in SA 2021-0017. I believe where we left off was to get started with Mr. Robertson's testimony. Before we do that, I wanted to mention that I did have a chance to take a look at the document that Mr. Cooper circulated. Does anyone else have any comment on that document or any concerns about it? I didn't see any reason why it wouldn't be adequate to help us establish the vote in regard to the Hallsville sewer system. Does anyone have any concerns? Okay, my understanding is that that would be filed as Missouri Americans Exhibit 8, and I would just ask that that be filed by the 12th if possible. Did you have any other comments or questions about that, Mr. Cooper?
I do not.
Okay, thank you so much. Does anyone have any other preliminaries before we get started with Mr. Robertson? Okay, so I believe I have spotted Mr. Robertson here on my screen. And if you would speak up for a minute and we'll make sure we can hear you.
Good afternoon, Judge.
Okay, good. We're able to hear you. Could you raise your right hand, sir? Do you solemnly swear or affirm that the testimony you will give in this hearing today will be the truth?
Yes.
Thank you very much, sir. Mr. Pringle, you may proceed.
Thank you, Judge, and also I apologize in advance if my cat keeps jumping on my shoulders. She was good all morning, but now something changed.
You'll be forgiven.
Thank you, Judge. Good afternoon, Mr. Robertson.
Good afternoon, Mr. Pringle.
Could you please state and spell your name for the court reporter?
Jared Robertson, that's J-A-R-R-O-D, Robertson, R-O-B-E-R-T-S-O-N.
And Mr. Robertson, by whom are you employed and in what capacity?
I'm a data research analyst with the Missouri Public Service Commission.
And are you the same Jared Robertson who contributed to staff's recommendation to grant CCN, previously entered into the record as Staff Exhibit 100?
I am.
Did you also cause to be prepared the rebuttal testimony of Jared Robertson, pre-marked as Staff Exhibit 101?
Yes.
Do you have any additions or corrections regarding your rebuttal testimony at this time?
I do not.
If I were to ask you the questions contained in Exhibit 101, would your answers be similar or substantially similar today as those contained herein?
Yes. Yes.
Are those answers true and correct to the best of your knowledge and belief?
Yes. Yes.
Thank you, Mr. Robertson. Staff moves to enter Staff Exhibit 101 into the record.
Thank you very much. Is there any objection to Staff's Exhibit 101, which is Mr. Robertson's rebuttal testimony? Okay, Staff's Exhibit 101 will be admitted to the record. I believe we might be getting a little bit of an echo from Mr. Robertson's line, so I will ask Mr. Pringle to mute in case that's the source of that echo.
Not a problem.
Thank you. Okay, so any cross-examination from Missouri American?
No, Judge. Thank you.
And from the district?
Yes, Judge, I have a few questions.
Please proceed.
Thank you. Mr. Robertson, is it a fair assessment or statement from your testimony that you evaluated Mr. Roderman's concerns, the district's concerns about the issue of continuing authority?
Yes.
Did you or any other staff, to your knowledge, perform any evaluation of the boundaries of the Boone County Regional Sewer District outside of the continuing authority issue?
Could you rephrase that again? I'm concerned if you're asking about service area boundary or something beyond that.
Well, there was some testimony, and it's addressed in the staff report, about what the district's boundaries are for purposes of its level 2 continuing authority. And my question is, outside of that context, boundaries of the district's level 2 continuing authority, did you or any other person on staff, to your knowledge, evaluate boundaries of the actual sewer district, which it was a voter approved district in terms of its service area?
Not that I'm aware of.
Okay. And so would it be fair to say that the evaluation of boundaries was limited to what the boundaries are for purposes of the district's level 2 continuing authority?
Could you state that question again, please?
Sure. I'm just trying to establish that the only boundaries relating to the district that factored into staff's analysis were boundaries of where it could exercise its level 2 continuing authority approved by the Missouri Clean Water Commission.
I may not be understanding the question correctly in that in reviewing the application in front of us, staff reviewed the service area boundary as it relates to the city. And then are you asking me further information related to the continuing authority?
Well, I'm asking, as I mentioned a moment ago, there is a discussion in the staff's investigation report about whether the district's level 2 continuing authority boundaries includes incorporated areas of Boone County. And my question is, were those, for purposes of boundaries of the district and what the staff considered in its investigation, were the only boundaries of the district that were evaluated level 2 continuing authority boundaries versus the district's entire service area as approved by the voters of Boone County when it was formed and approved and created as a public sewer district under Chapter 204?
Correct.
Okay. And do you agree that the district's level 2 continuing authority includes unincorporated areas of Boone County?
You'd be asking me to speak on DNR regulations, which I am not an expert on.
Okay. Did you form any opinion in your capacity of being a staff member of this commission as to whether the district's level 2 continuing authority includes unincorporated areas of Boone County?
I believe that's more open-ended. We did not come to conclusion. We left that as a posed question, and in that we are not in a place to make such determination.
Okay, thank you. And in conducting staff's investigation, did you, or to your knowledge, any member of the staff evaluate any of the Boone County Regional Sewer District's regulations?
No.
We heard some testimony earlier today from Mr. Bush about whether the staff concluded that the condition proposed and recommended by staff that Missouri American initiate negotiations with the district for new contracts for the Sunny Slope and Silver Creek subdivisions within 30 days of receiving its operating permit from DNR, whether it was the staff's opinion that that condition was essential for the requested CCN to be necessary and convenient for the public service. And my question to you is, does staff believe that requiring that condition on the grant of the CCN is essential for the requested CCN to be necessary and convenient for the public service?
Continued service for those customers is essential, yes.
Okay. I don't have anything further at this time.
Because that was somewhat jumbled, Mr. Robertson, I'm going to ask you to restate your answer to that question. It was the audio.
Oh, no problem. My fault. I'm sorry. Jen, continued service for those customers would be essential for the staff. Yes.
Thank you very much. Okay, I'm going to let the commission know that if commissioners have any questions, we can take those now. I do have a couple of questions to ask Mr. Robertson. First of all, I know that there is an attachment scheduled JJR or JJR S1 to your testimony. It did talk about your work experience, but it doesn't seem to include your educational background. Could you describe your educational background for us, sir?
I have an undergraduate degree in biology from Columbia College in Columbia, Missouri.
So do you have a bachelor's degree, an associate degree? What is your level?
I'm sorry. Yes, bachelor's degree.
So that was a bachelor's degree in biology from Columbia College?
Correct.
Thank you. And Ms. Griffin had already asked you about the condition that I was interested in asking you about, so I didn't have any additional questions for you at this time. Unless commission questions come in, we can proceed now to recross if Missouri American has anything that they would like to ask.
No questions, Judge.
And the district, did you have any recross, Ms. Griffin?
No, Judge.
And did you want to do any redirect, Mr. Pringle?
Yes, Judge, briefly. Mr. Robertson, as part of the water and sewer staff of this commission, is reviewing continuing authority a regular part of your duties?
No, it is not.
Does the commission have jurisdiction over continuing authority?
No.
Who does?
Department of Natural Resources.
And during staff's investigation, did staff review any kind of minutes or agenda from Department of Natural Resources pertaining to the district's award of level 2 continuing authority?
Could you ask me that question again? I'm sorry.
In staff's recommendation, is there any discussion about the agenda or minutes that led to the Clean Water Commission approving the district's level 2 continuing authority?
Regarding minutes, I would have to look back at the testimony. I'm sorry.
Okay. Well, if you could you do you have a staff recommendation in front of you?
I sure can, and I do.
All right. Thank you, Mr. Robertson. If you would turn to page 3 of staff's recommendation. In Exhibit 100, that would be page 8 of 25.
All right, so I got 3 of 15 from the memo, I believe.
Oh, sorry, yes. Page
Okay.
15 in the exhibit, that's correct.
I'm there.
Okay, and then when you look at footnote 4.
Yes.
What was the result of staff's review of the minutes and agenda of the Clean Water Commission when the level 2 authority was given to the district?
Well, essentially that the entirety of the collection system is within the municipal boundary, and the majority of the wastewater treatment facility is within unincorporated Boone County, and it does not appear that the district would hold level 2 authority within the corporate boundaries of the city.
And why is that?
As the district requested and the CWC approved level 2 continuing authority in only the unincorporated areas of Boone County as they existed at the time of CWC approval.
Thank you, Mr. Robertson. I have no further questions, Judge.
Thank you very much. I don't believe we have any additional pending questions for Mr. Robertson, so thank you very much for your testimony today, sir, and you are potentially subject to recall, so if you can remain available for the duration of the hearing, we would appreciate that.
Thank you, Judge.
Thank you. Okay, so I believe that we would be ready then for Mr. Young, Matthew Young. And I can see Mr. Young. He is appearing on my screen on a different set of pages. So hopefully he'll pop over when he speaks up for us. Mr. Young, can you speak up so we can hear you today? Okay, so I didn't hear that. Let's check your audio and make sure you don't have something muted on your end. You don't appear to be muted on our end. I'm going to mute and unmute you and see if that does anything. This says request unmute. So and that didn't change anything. So what I'm going to ask you to do, sir, is disconnect entirely and then rejoin the call. Okay? I am assuming that no one else was able to hear Mr. Young.
That's correct, Judge. I couldn't hear him.
Okay.
I'm back, Judge.
Oh, great. Now we can hear you. Okay, great. We can see you and we can hear you. So if you would like to raise your right hand, please, sir. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
Yes.
Thank you very much. Mr. Pringle, you may proceed.
Thank you, Judge. Good afternoon, Mr. Young.
Good afternoon.
Please state and spell your name for the court reporter.
My name is Matthew, M-A-T-T-H-E-W, Young, Y-O-U-N-G.
And Mr. Young, by whom are you employed and in what capacity?
I'm a senior utility regulatory auditor for the staff of the Missouri Public Service Commission.
And are you the same Matthew Young who contributed to staff's recommendation to grant CCN, previously entered into the record as Staff Exhibit 100?
Yes.
Did you also cause to be prepared the surrebuttal testimony of Matthew Young, pre-marked as Staff Exhibit 102?
Yes.
Do you have any additions or corrections regarding your surrebuttal testimony at this time?
No, I don't.
If I were to ask you the same questions contained in Staff Exhibit 102, would your answers be the same today or substantially the same as those contained herein?
Yes.
Are those answers true and correct to the best of your knowledge and belief?
Yes.
Thank you, Mr. Young. Staff moves to enter Staff Exhibit 102 into the record.
Thank you very much. This testimony is Mr. Young's surrebuttal testimony, which has been pre-marked as 102. Does any party have an objection to admission of that exhibit? Hearing no objection, Exhibit 102 will be admitted. Okay, we are now ready to move on with cross-examination, and I'm going to ask Mr. Pringle to mute for us. Thank you. We can proceed to any cross from Missouri American.
No questions, Your Honor.
Thank you. And any questions from the district?
Yes, Judge. Mr. Young, in your surrebuttal testimony, you testified that the feasibility study submitted in a CCN application provides insight on the financial ramifications of the application and the effect the application may have on ratepayers of the new system and general body of ratepayers. And my question is, how can staff make a credible determination as to the effect of Missouri Americans' application on ratepayers and the general body of ratepayers without having information about the solution Missouri American will use to remedy compliance issues at the Hallsville system and the cost of that remedy?
While the cost of the solutions wasn't included as part of the feasibility study, we did get those figures from data request responses, and staff was able to work those into the figures and calculations and come to a general conclusion that it's likely not going to be detrimental.
What was staff able to make any sort of determination in terms of an actual dollar amount of what the impact would be on the ratepayers and general body of ratepayers with the information it had?
No, that kind of determination is impossible. But by the time that Missouri American incorporates the Hallsville system into its rates, everything will have changed from customer count to revenues to expenses to rate base. And so an exact determination is not possible.
I have nothing further.
That's my first time today I've forgotten to unmute. Okay. Do we have any questions from commissioners at this point? If we do, please speak up. I imagine, Mr. Young, that in your experience with the staff of the commission that you are experienced in reading tariffs. Is that something that you do?
I'm sorry, I'm experienced in what?
Reading tariff sheets.
The tariff sheets are actually not, preparing them and editing them are not part of my job. I do reference them.
Do you know how to look at them to get information?
Yes.
Okay. So I was hoping that we could talk about the feasibility study in this case. I understand that you worked with that. Is that right?
That's correct.
Okay. And the amount that's shown on the feasibility study in this case that was submitted by Missouri American, as far as the rate that would be charged for Hallsville customers, can you tell me what amount is stated on that study, understanding that it's a confidential document, but that figure is not confidential?
Yes, the amount is $38.75 per customer.
Okay. And did you have an understanding about where that figure came from?
It's my understanding that that's Missouri American's current tariff rate for this area of Missouri.
Okay. And do you have access to EFIS at this time so that you can look at documents?
I do.
Okay, so there is a document that was admitted to the record as Commission's Exhibit 300, and that was actually attached to a filing on April 5th. So if you're looking at the most recent documents, it should be the latest filing in the case.
Okay, I'm there.
And then attached to that is the proposed Exhibit 300. Could you open that up, sir? If anyone else needs time to get to these documents, go ahead and let me know. Okay, so can you tell us, I believe it's 4 pages. Can you just describe what we're looking at there?
This appears to be Missouri American's current tariff. Page 1 would be for the city of Arnold. Page 2 would be for all other areas of Missouri.
And it must not be all other areas because there's 2 more sheets. So what's page 3?
There's one moment while I look at this. Okay, just a quick review. Page 2 appears to be a rate for high volume customers outside of the city of Arnold. And as my understanding, Missouri American has a rate for low volume customers, and that is on page 3. Page 4 discusses a volumetric charge that I'm not familiar with.
Is there a
Looks
notation?
like it's for the city of Lawson.
Okay. Is there a notation on the feasibility study that references Arnold in relation to the 3875 figure?
Yes, there's a notation that's
What does it say?
It indicates that customers placed on existing lower rate for non-Arnold sewer customers is what they used in the feasibility study, which means the 3875 tariff rates.
Okay, so would that be the tariff rate or the tariff sheet, which is third revised sheet number RT 3.1 that indicates the 38.75, or I'm sorry, $38.75 rate?
Yes.
Okay, so would it be your understanding that this is the tariff sheet that rate was drawn from?
That's my understanding, yes.
Okay. Okay, I did not want to make any assumptions and wanted to run that by someone who would know. So I thank you for your testimony on that. I don't think I have any questions. Okay, so unless there are commission questions, we can proceed to see if there's any recross from Missouri American.
No questions, Your Honor.
Thank you. And does the district have any additional questions?
No.
Any redirect from staff?
No redirect, Judge.
Thank you very much. Okay, Mr. Young, thank you so much for your testimony today. You're excused from the stand. It's possible you could be recalled, so I hope you'll remain available today until we wrap this hearing up. Thank you. Looks like we are ready to proceed with Mr. Williams. And I'm looking. There we go. We have Mr. Duran Williams, I see, has joined us. Are you ready to proceed with the next witness, Mr. Pringle? Uh-oh. Think you were muted.
Yes,
That's okay.
Judge.
It's all right. I confused you. I made you mute. Okay. So, Mr. Williams, if you would please raise your right hand for us, sir. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do, yes.
Thank you so much, sir. Mr. Pringle, you may now proceed.
Thank you, Judge. Good afternoon, Mr. Williams.
Hello, good afternoon.
Please state and spell your name for the court reporter.
Sure, the name is Duran A. Williams. Duran is Daronn, and A. Williams, Williams.
And Mr. Williams, by who are you employed and in what capacity?
I am an associate engineer with the Missouri Public Service Commission.
Are you the same Duran Williams who contributed to staff's recommendation to grant CCN, previously entered into the record as Staff Exhibit 100?
Yes.
Did you also cause to be prepared the surrebuttal testimony of Duran Williams, pre-marked as Staff Exhibits 103C and 103P, and this is your corrected surrebuttal testimony?
Yes, that is true.
Do you have any additions, corrections regarding your corrected surrebuttal testimony at this time?
No, I do not.
If I were to ask you the same questions contained in Exhibit 103C and 103P, would your answers today be similar or substantially similar as those contained herein?
Yes.
And are those answers true and correct to the best of your knowledge and belief, Mr. Williams?
Yes.
Thank you, Mr. Williams. At this time, staff moves to enter Staff Exhibits 103C and 103P.
Okay, Staff Exhibit 103P and Staff Exhibit 103C, which are the corrected testimony of Mr. Williams in public and confidential form. And those corrected versions have been circulated to the parties, have been offered on the record. Are there any objections? Hearing no objections, those exhibits will be admitted. And we can now proceed to cross-examination, and I'll ask Mr. Pringle to mute again for us. Thank you. We would start with Missouri American if there are any questions.
No questions, Your Honor.
Okay, and then any questions from the district?
Yes, Judge. And just as a preliminary matter, I want to make sure that I don't divulge any confidential information. And I would note that the overview, reasoning, and estimate of the 5 possible long-term solutions proposed by Missouri American that are contained in Mr. Williams' corrected surrebuttal testimony are marked as confidential. And I just wanted, I have some questions about the evaluation, not so much the numbers. And wasn't sure if it was just the numbers that were needed to be treated as confidential, or if all of it needed to be treated as confidential and it was marked. So I thought I would just ask.
Thank you for raising that issue. Mr. Cooper, can you help us? Oh, I'm sorry. Well, this is an interesting question, actually, because it's the company's proposals, but it's come to us through staff. So actually, Mr. Pringle and Mr. Cooper, please help us out here.
I would defer to Mr. Cooper and the company, seeing as how it is their information.
That's what I would have done as well if I were Mr. Pringle. Let me see if Mr. Luft is still on, or Mr. Horan is still on.
I'm here.
So I can confirm this with them. Mr. Luft, what my thought is that it's the numbers, it's the estimates that are truly confidential because of the potential for bidding those, or
Exactly.
and that the options themselves are not confidential. Would that be accurate?
That's right. That's exactly right. You don't want people bidding on these things.
Yeah, you don't want them to have those estimates at the time they bid, right?
Putting their bid together.
Okay. Is that clear as mud?
Yeah, I think so. I think all of the questions I have just relate to aspects and evaluation of the 5 options, not the dollar numbers.
Yeah.
Okay, I just wanted to be sure.
Thank you.
Mr. Williams, would you agree that in your testimony, which is your corrected rebuttal testimony that's in the record, that you provide an overview and reasoning for 5 potential long-term solutions for the Hallsville system that were proposed by Missouri American to staff?
Yes, that is true.
Okay. And is spray irrigation with land application one potential issue, or excuse me, one potential solution that you evaluated that was proposed by Missouri American?
Yes.
Okay. And in your analysis, did you conclude that some issues with the landowners created a potential problem with effective use of this option?
It is an obstacle, if you will, that would need to be addressed for long-term use.
Okay. And is that because in part of dirt work projects done by one of the farmers that has resulted in partially treated wastewater entering waters of the state and resulting in non-compliance?
Well, in my opinion, the main factor is because but like currently the application, the land for application is not owned by the city, so the landowners, the farmers themselves, basically have the final say on when their land can be used. And so that is the ultimate issue with the current situation.
So is it fair to say that based on your evaluation, the lack of control over the land since it's leased is an issue?
Yes.
Okay. And you noted in your testimony that securing nearby land and owning the spray irrigation equipment would avoid the issues over control with the land being leased from farmers, correct?
Yes, that is one option to create a better situation for any form of land application.
Okay. But you also indicated that it might be difficult for Missouri American to acquire land for use for land application, correct?
There's always the possibility of they're not working out. So yes.
And what facts or information did you base your conclusion that it might be difficult for Missouri American to acquire the land needed for land application?
Well, because the current is my understanding that that the farmland may be a multi-generational farmland, and it sounded like when I was on site during the inspection that the farmers may or may not be interested in selling, but that'll be an issue that if MAWC is granted the CCN, they would follow through and assess that situation at the time.
Okay, so your conclusion was based on information you obtained at the time the staff conducted an investigation of the Hallsville system?
Correct.
And did you conduct any sort of evaluation of how much land Missouri American would need to secure for spray irrigation with land application to be a viable option?
I did not know.
Okay. Do you know how much land is required by the current permit for land application for the Hallsville system?
I do not know.
If Missouri American is unable to secure whatever land may be appropriate or necessary for land application, would it still be your opinion that spray irrigation is a viable long-term solution for Missouri American?
So the question is, if they are unable to acquire the necessary land to conduct the spray irrigation, would it still be a viable option?
Yes, sir.
Yes, sir. No.
Okay. The next option that you evaluated was for a drip irrigation system, correct?
Correct.
Okay. And would you agree that this potential solution, like the spray irrigation option, would not be a viable option if Missouri American would be unable to acquire land needed for land application?
Well, since this is my first time testifying before the commission and judge, I do have a correction to the original question. So what would be the best way to address that?
I think you should just proceed to answer the question that you were asked, sir. And if you need to elaborate to clarify something that you said earlier, you should be able to do so. So start with Ms. Griffin's question.
Okay, so to answer your question about the drip irrigation and also the spray irrigation, yeah, if land, besides acquiring their own land to do the irrigation, another viable option is to basically work a better deal with the current farmers. So to better ensure that the land would be able so the land would be used as needed and more consistent than it is currently being used.
Okay, I think I understand what you're saying. Do you know, Mr. Williams, how many years that the land has been leased by the city of Hallsville from the two farmers that we're talking about?
I know, well, I do not know the overall time, but the contract information is in the staff memo on when the contract started for the former to the north near cells 1 and 2. And I know that contract is for a 10-year period, and that expires, I believe next year in 2022. But I'm not sure for like how long they've been using the land application system on those lands.
Is it your understanding that those leases have been continuing for a period of years?
Yes, that is my understanding.
And is it also your understanding that there have been problems for a period of years with these particular farmers?
Well, not exactly. It is my understanding that there's just been concerns regarding the field to the south near cell 2. And if I may, the other contract for the former to the north actually ends September 15th, 2023. So please forgive me.
Okay. Do you know when that contract was renewed last?
No, it's for a 10-year period. So obviously it went into effect in 2013.
Okay. And I'm looking at the case file memorandum right now, which is schedule JAB D2. Are the references to, well, let me just read this sentence and then I'll ask you a question. On page 11 of that report, in the first full paragraph, it says, the city has no control over when and how long the landowners operate the pivots. The city's operator told staff during its inspection that even though the landowners in the city have a written agreement, the landowners often do not follow its terms, including failing to notify the city before the pivots are turned on and failure to keep a monthly log of the pivots operation. Were you present when the city's operator made that statement? Those statements?
Yes.
Okay.
I guess I was.
And so I guess what I'm trying to get at is if there's a history of these landowners not following the terms of the written agreements that they have with the city, why do we have any reasonable expectation to believe if a different agreement is negotiated with Missouri American that they will follow the terms of that agreement?
Well, I'm not a lawyer, so I can't really speak to those specifics. But if the contract had more, language regarding the day-to-day operations and expectations, there's a chance that the farmers, especially the farmer for the South, may be more amicable, more easier to work with, but yeah, that would be a question for an attorney, I would think.
Okay. When evaluating the drip irrigation system option, did you factor into your analysis whether any permits would be required from Boone County?
Boone County, like the as in the county officials?
Correct.
No, that was not evaluated.
And when evaluating this option, did you consider whether the Boone County Regional Sewer District's regulations would require Missouri American to submit any plans to the district for approval?
No.
Okay. Well, assuming that additional approvals or permits were required from either Boone County or the district, and Missouri American was not able to obtain those approvals, would a drip irrigation system be a viable option for the Hallsville system?
Well, that would be a decision for them to make at that time.
But as you're sitting here today, if there were permits or approvals that had to be obtained in order for them to alter the current Hallsville system and make it a drip irrigation system, would Missouri American be able to do that without necessary approvals or permits?
If the parameters to allow a drip irrigation system was not acquired or obtained, then the option would not be viable.
Okay. And then the third option that you evaluated was a new mechanical plant, right?
Yes.
Okay. And did you evaluate whether Missouri American might need any additional land if it selected this as a long-term solution for the Hallsville system?
It just depends on the parameter of the plant, like how big of a footprint they would need. But in theory, like assuming that if they would close one of the cells, they would have plenty of land to operate a mechanical plant in lieu of a 3-cell lagoon system. But there also is land, near, in the parcel of cell 2, which is the larger cell, that, in theory, that land could be used to, if they chose to, use the lagoon system and the mechanical plant. But until pretty much anyone any new owner operates the system and gets real-time data, they won't be able to, then they will be able to make an informed decision on the most viable option.
Okay. So, and I'm just trying to understand your testimony. Is the answer to my question maybe that you are unsure whether Missouri American would need any available land at this time?
That is a decision that I am unable to make because it depends on how big of a footprint the mechanical plant would require.
Okay. And when evaluating the option of a new mechanical plant, did you consider whether Missouri American would need to obtain any permits from Boone County or approvals from the district?
The only outside entity that I considered was the Department of Natural Resources.
Okay. And with respect to the department, are you referring to the need for Missouri American to obtain a permit for the new plant?
Yes, an operating permit, and also if for the mechanical plant, it would go from a no discharge system to a discharge system, and that would require an anti-degradation review.
So you're saying that the proposition for a new mechanical plant would involve a discharge facility as opposed to a no discharge facility?
Yes.
Okay, I didn't see that in any of the information that was provided regarding that plant. So I have kind of the same question that I had at the end of our discussion about the drip irrigation system.
Sure.
Assuming that Missouri American was unable to secure any necessary permit from Boone County or approval from the district, would constructing a new mechanical plant be a viable option?
Just as before, and with each option, if the required parameters if they are unsuccessful in acquiring the necessary parameters for this option, then they would need to choose a different option.
Okay. And is it correct to say that the fourth potential long-term solution that Missouri American proposed and that you evaluated was the direct discharge with triple point ammonia removal technology option?
Yes, that is the fourth option.
Okay. And that option would involve a discharge, correct?
Yes.
Okay. And do you know if the existing Hallsville system is permitted by DNR as a discharge or a no discharge facility?
It is currently permitted as a no discharge system.
Okay, just for purposes of helping all of us understand, could you explain what the difference is between a discharge facility and a no discharge facility?
I will do my best. It is my understanding, so a no discharge system is a wastewater treatment system where where it is designed that the waste water, also known as effluent, does not directly go into the waters of the state. In the current system, the way the Hallsville system is currently designed as a no discharge system, it's obviously it's set up with irrigation fields, and the idea is for the crops in the soil to absorb the water without the water going to waters of the state. And so a discharge system would be basically a wastewater treatment system where the effluent goes directly into the waters of the state.
Okay. And isn't it generally true that, generally speaking, that a no discharge facility would be more protective of the environment than a discharge facility?
I would say no. One, that's a question and a stance for DNR. And then two, it's that would be something that like where all factors would need to be evaluated to make that call.
You mentioned in your testimony that this direct discharge with triple point technology would be contingent on DNR's approval to allow Missouri American to discharge from the existing lagoons used in the Hallsville facility. And is that because the lagoons currently are not allowed under the existing permit to discharge to the waters of the state?
Basically, as stated earlier, because the Hallsville wastewater treatment system is currently deemed as a no discharge system, to go from a no discharge system to a discharge system, an anti-degradation review is required, and that
Okay.
is something that that DNR does after a CCN and operating permit is are issued.
Yep, and you kind of walked right into my next question, which was, do you know what process Missouri American would need to follow to seek DNR approval of this option? And it sounds like your testimony is that to pursue this option, Missouri American would need to ask DNR to perform an anti-degradation review.
Right, and basically, yes.
And do you know what kind of an evaluation the DNR makes when it conducts an anti-degradation review?
I am generally familiar with it, but basically they would evaluate like what is the best option for the situation, and if and yeah, actually, I am not familiar with all of the details of the anti-degradation review.
Okay. Do you have any knowledge about how long the process normally takes to go through?
I do not, no, ma'am.
Okay. And are you aware of any instances in which DNR has approved a no discharge facility converting to a discharge facility using this triple point ammonia removal technology?
I am not familiar with all of the wastewater treatment plants that DNR regulates, nor do I know of of a specific example of a no discharge system going to a discharge system using the triple point. I do know of instances where the triple point technology have been used, and according to DNR, there are a great number, depending how you define that, of the triple point system being used, and it has deemed to be successful to reaching DNR effluent standards.
Okay, but you're not aware that any of those facilities that you're referencing, of them having formerly been permitted as no discharge facilities?
That is correct. I am not aware of any that went from a no discharge to a discharge system.
Okay, and when you evaluated this triple point potential solution, did you consider whether Missouri American would have to obtain any approvals from Boone County or permits or permits or approvals from the district?
It's my understanding that they would not have to receive any special permits from those entities. It's a technology that is used by a number of sewer utilities throughout the state.
Okay. The last option that you evaluated was the direct discharge with plant upgrades, correct?
Yes.
Okay. And is this, as it sounds, also an option that would involve converting the Hallsville facility from a permanent no discharge facility to a discharge facility?
Yes, that is correct.
Okay. And so would your testimony be the same as for the triple point option in terms of this option would require DNR approval and require an anti-degradation review before it could be used? Okay.
Yes, yes, it would. It would also require the anti-degradation review.
Okay. And did you consider for this option whether Missouri American would have to obtain any approvals or permits from Boone County or the district to implement it?
It is my understanding, just like with the other options, that the only approval they would need after getting a CCN from the commission here would be approval permits from the Missouri DNR.
Okay. And if the Missouri, excuse me, my computer's giving me some feedback here. In the event that the DNR would not approve either the direct discharge with triple point technology option or the direct discharge with plant upgrade option, would those be viable options for Missouri American for the Hallsville system?
If a Missouri American receives permanent roadblocks to any of the situations, I mean, any of the proposals, then they would need to find a viable option.
I don't have anything further at this time.
Okay, thank you very much. We would now have the floor open for any questions from commissioners. If we have any. There was one thing I wanted to clear up. Mr. Williams.
Yes, Judge.
Okay. So I just wanted to ask you, is a mechanical plant something that always would be classified as a discharge system, or might it be a no discharge system depending on how it's set up?
Thank you, Judge. That's a good question. Was my understanding typically that it is a discharge system, but of course, depending on the situation, it could be a no discharge system with land application or a different means to to deal with the final effluent, whether it was hauled off or but typically I don't hate to throw out a number, but 99% of the time, or at least I've only seen a mechanical plant being a discharge system, but given the parameters, it is possible for it to become a no discharge, or will be a no discharge system as well.
Okay, thank you for clarifying that. That is helpful. There was another thing I wanted to clarify with you. Is someone else trying to get in there? Perhaps I'm hearing my own voice bouncing back at me. Okay. I was hoping that you could look at schedules or a schedule attached to Mr. Horan's sir rebuttal testimony, which is now in evidence. That's schedule MH-5C. And that is a confidential schedule, but I'm not really asking you about any substance there. What I wanted to do was ask you if you could tell me the relationship between that schedule and the schedule attached to your own testimony, which is schedule DAW-S2, which is multiple pages.
Okay.
I don't want to make an assumption about the relationship between those schedules, so I was hoping that you could make it clear for us.
Sure. And that is, well, so you said MH5C. Let me pull that up. I believe I know which schedule that you are speaking of. But I
It's
want to.
multicolored in the version I saw. It has.
Yes.
Okay.
And it's 5C. Okay. Yes. Yes. And so so it what's presented in MH5C is the exact same thing that I have. Instead of having it color coded like Mr. Paran, I just have them on separate pages for ease.
Okay, so I just wanted to make sure that I didn't have to go through those line by line and see if there's any differences. Essentially, did you take information provided to you from Missouri American and then converted it to those multiple pages to attach to your own testimony?
I did.
Okay.
Yes.
All right, thank you. Okay, do we have any recross from Missouri American?
No questions based on the questions from the bench.
Thank you. And anything from the district, Ms. Griffin?
No, Judge.
I feel like we have some audio problems that are developing here this afternoon. I hope they go away. Any redirect by staff?
Yes, Judge. And Mr. Williams, regarding the 5 proposals in your Cerebell testimony, how practical is it for MAWC to have detailed proposals prior to operating the system themselves?
Well, it is not practical, nor does staff expect a detailed proposal before they operate the system.
Why is it so important for Missouri American to operate the system itself before coming forward with a detailed proposal?
Sure. It's important for them to be able to operate to operate the plant and get real-time data, because there's various moving parts and parameters that would need to be identified and evaluated, and until those issues and any day-to-day operation, and so I'm sorry. It's important to see the day-to-day operations to develop a permanent long-term solution for the concerns with the system.
And is there anything limiting Missouri American Water from choosing only from these 5 proposals?
No, no.
And also, just wanted to clear up what from your cross-examination by the district, Mr. Williams. Did you say you had a correction you wanted to make to your testimony regarding drip irrigation, or is that not the case?
Yes, I'll take that opportunity. So yeah, I wanted to just share that with the land application options, the spray irrigation and drip irrigation, those options could be used with the current farmers, or oh my gosh, they could be used with the current farmers and with adequate storage and land application, and they can also be used if Missouri American purchased additional land.
Okay, Mr. Williams, is that a correction or just an elaboration?
And elaboration.
All right. Thank you, Mr. Williams. I have nothing further, Judge.
Thank you very much. Thank you for your testimony today, Mr. Williams. You are excused at this time, but please remain available if at all possible until the hearing has completed in case we need to recall you. Okay?
Our judge, thank you.
Thank you very much. And I do understand that the commission will not have additional questions for Mayor Carter today. Do any other parties have any reason why they would request his recall at this time so we can let him know that he doesn't actually have any childcare concerns this afternoon? Okay, Mr. Cooper, you can go ahead and let Mr. Carter know, or if he's with us. Mayor Carter, thank you so much for appearing today. You'll be excused and you should not be subject to recall.
Thank you, Judge.
Okay, and speaking of recall, because it occurs to me that given Missouri American's recent at least approval of the stipulation and agreement, I think there are usually a few other subsequent steps that might take place after a rate case resolves, but it appears that Missouri American's pending rate cases, the commission just issued the order approving the stipulation and agreement. My understanding is that staff's proposal in this case was that depreciation rates would be based on the previous rate case, and then those rates were in fact established in the current rate proceeding. So the issue is, can we just stipulate that those are indeed the facts? Is it necessary to bring a staff witness back to confirm that information? What would you prefer, Mr. Pringle?
Could you repeat that one more time, Judge? You cut out on me towards the
Oh,
end.
I'm sorry. Okay, I apologize. I hope my audio is okay. All right. So this pertains to staff's recommendation as to depreciation rates that would be required if a certificate were approved. My understanding is that staff was recommending depreciation rates that were set in what had been Missouri American's most recent rate case. And I believe that those were carried forward into the stipulation and agreement the parties reached in the very most recent rate case, which is in the process of resolution right now, with a commission order issued on Wednesday. So my question is it necessary to bring back a staff witness to confirm the recommendation and let us know which cases those are? I don't think this is an issue in controversy. So the alternative is to stipulate that is the state of affairs.
I would lean towards stipulate, Judge. It is staff's understanding that depreciation rates are not changing between the rate cases, and we'd be fine to stipulate. Really, we leave it up to you. If you prefer to have a staff witness come forward, we can do that too. But I think stipulation would be the easiest way forward.
And Mr. Cooper?
We certainly would stipulate that there's no change in the depreciation rates from case to case as identified in the stipulation.
Okay, thank you. And Ms. Griffin?
We would stipulate as well.
Okay, I'm comfortable that because this is not controversial in any way, that combined with your statements all today on the record and what is expressed in staff's recommendation, that this should be well established for purposes of our record. So thank you for that. Okay, we have just finished with Mr. Williams, which means we've finished with staff's witnesses and we are ready to get started with the district's witnesses. So I anticipate that Mr. Ratterman's testimony may be extended to some degree. We're about 15 minutes shy of when I would normally want to take a break. So I'm going to propose that we take a break right now until 2:30 and get back to start with Mr. Ratterman. So we will be in recess until 2:30. Thank you.
C-O-N-N. Tunneling, C-O-N-N, tunneling, C-O-N-N-E-L-L.
This is Sherilyn Voss. Just wanted to give a heads up that someone who may think they're muted may not be, because I just heard a snippet of a conversation. So if you want to be muted, I would double check.
Judge,
Yes.
this is Nathan Williams for Public Counsel.
Yes.
You did not ask about us joining in the stipulation.
I didn't. I realized that. So when we get back on the record, I will address that.
Okay.
My apologies.
This is a court reporter, Judge. Can you hear?
I can hear you. Can you hear us?
Yes, ma'am. I just have a question for two terms for clarification. Was Mr. Williams saying 3-cell lagoon system?
Yes, I believe so.
CELL?
Yes, CELL.
Okay. And then triple portion system, or triple point system. Is that right?
I believe it's point.
Okay.
P-O-I-N-T.
I don't have.
Okay. Now we know we can speak to our court reporter. Ms. Banks, will you be ready to go at 2:30?
Yes, ma'am, I'm ready.
All right, great. All right, everybody, we're back together. It is, we'll get back on the record for this hearing. It's SA 2021-0017. It is now 2:30 p.m. Mr. Williams mentioned to me that I had neglected to ask the Office of the Public Counsel if the Office of the Public Counsel would also agree to the stipulation concerning the depreciation rates and staff's recommendation. Mr. Williams, would you like to go ahead?
Yes, staff will stipulate to that, and staff also has no objection if the commission wants to take notice of its order yesterday approving stipulation and agreement in case number WR 2020-0344.
I appreciate that suggestion, and that may in fact be useful. So I think we've now established that OPC has no objection to the stipulation that the other parties had agreed to. I think it may be useful to us in this case to take notice of the order issued in that rate proceeding, which is WR 2020-0344, I believe.
That's correct.
Okay, great. So are there any objections to that order being incorporated into the record in this case by reference? And that would be the order issued at the commission's agenda on Wednesday, April 7th in WR 2020-0344. I'm seeing that staff counsel, Mr. Pringle, has indicated no objection. Mr. Cooper has no objection as well, and Ms. Griffin. And in this case, it was the suggestion of the Office of the Public Counsel. So happily, OPC has been included. So that is what we will do in this case. That order is incorporated by reference into the record in this case. Thank you very much. All right. So we are ready, I believe, to get started with the district's witnesses unless there are any parties with any preliminaries that they would like to bring up before we bring Mr. Ratterman on. Looks like everyone is ready. Ms. Griffin appears to be ready. So Mr. Ratterman, if you'd like to initiate your video line and speak up, and we will get you sworn in.
Good afternoon, Judge.
Okay, here you are coming on my screen here. There we go. It's very difficult visually the way people are moving around. I keep looking for people's faces in one spot and they move, so then I can't find them. I now have Mr. Ratterman with us. Mr. Ratterman, could you raise your right hand, please, sir? And do you solemnly swear or affirm that the testimony you will give in this hearing will be the truth, sir?
I do.
Thank you very much. I'm not sure if you're responsible for this line, Ms. Court Reporter, but it seems like I might be picking up something from your line. Are you definitely muted? Okay. All right, so Mr. Ratterman, I believe we're ready to proceed. There is some something's coming off of a line. I'm going to mute myself and that might help, and we can let Ms. Griffin take over. Thank you.
Thank you, Judge. Good afternoon, Mr. Rotterman. Could you please state and spell your name for the court reporter?
My name's Tom Rotterman. My first name's Tom. My last name is Rattermann.
By whom are you employed and in what capacity?
I'm employed by the Boone County Regional Sewer District, and I am the general manager.
Are you the same individual who caused to be prepared the rebuttal testimony of Tom Rotterman, which we have pre-marked as Exhibit 200?
Yes.
Do you have any additions or corrections regarding your rebuttal testimony?
Yes, I do have some additions. I'd like to respond to Mr. Haran and Mr. Robertson and Mr. Williams.
Judge, I'm going to object to that. I don't think that that's a proper part of our process to supplement testimony in this fashion at this point in the case.
So, can you just explain, Ms. Griffin? I apologize.
Well, there were some matters that came up in the SIR rebuttal testimony that the district has not had the ability to address, and that is the purpose of this testimony, is to respond to those items that were raised after we filed our testimony.
So the first thing you're doing here is introducing on the record Mr. Rotterman's filed testimony. Is that right?
Well, I wasn't sure since, as I've indicated previously, I'm new to the process. Since he had additions, what I had planned to do was ask him questions about additional information raised after his testimony was filed, and then enter his written testimony into the record. Obviously I could reverse the order. It doesn't really matter to me.
Okay, so it sounds like we have a dispute developing about to what degree you can ask any additional questions based on matters that were raised in SIR rebuttal, or yes, in SIR rebuttal. So could you tell us more about these specific issues so that I can consider what Mr. Cooper might be saying, and I'll let Mr. Cooper respond to that.
Certainly. Basically, I have some questions. There was a dispute raised about what the boundaries of the district are and what its authority is vis-a-vis Missouri American, if in fact the requested CCN is granted by this commission to enable this sale to go forward. And we wanted to address some matters regarding the continuing authority issues and the general authority of the district that were raised in that SIR rebuttal testimony. We also wanted to address some of the treatment options that were discussed and evaluated in SIR rebuttal testimony that was filed by the staff.
So I think what might make sense is to take these one issue at a time and one question at a time, rather than debate whether Ms. Griffin can ask any additional questions of this witness. And of course, I'm happy to hear what Mr. Cooper and Mr. Pringle have to say about this. Mr. Cooper?
Yes, Judge. We're working with a procedural schedule that, was set up a long time ago. It set out the rounds of testimony. And what Ms. Griffin seems to be discussing is essentially an additional round of testimony that would be conducted live in a way that we would not be able to respond to it. I think that the applicant, since it has the burden, is supposed to have the last shot at that. That's why it was set up in a direct rebuttal, SIR rebuttal sort of fashion. So I guess I just think that it complicates this process considerably if we're going to have a live additional round of testimony at the hearing.
And I would second Mr. Cooper's objection, Judge. It's just the point of the pre-file testimony is for us to review it prior to hearing. Having live testimony happen at this point, I think would be unfair to the other parties. And further, I think cross-examination really is the way to handle that SIR rebuttal. And I just think I agree with Mr. Cooper. It doesn't seem proper right now.
Would Mr. Williams with OPC want to provide any commentary on this issue?
I can give you some input based on my experience over the past 20 plus years in practicing in front of the commission. First of all, there may be changes to his testimony in light of what people said later. In other words, it wouldn't be what he'd said before in the pre-filing would not be his testimony currently. And so there would be a revision for that reason. In the past, I've seen the commission where someone raises a new issue in SIR rebuttal, allow parties to respond to that.
Okay, and I do apologize to everyone for needing to go back through this again. But Ms. Griffin, I believe one of the issues that I recall that you raised was the possibility of asking Mr. Ratterman questions about the proposed upgrades or system modifications that were identified in Missouri Americans and staff's SIR rebuttal. Is that right?
Yes.
Okay. So just taking that single issue alone of the specific modifications or upgrades addressed in SIR rebuttal, I would consider that is something that was elaborated on significantly in SIR rebuttal. And it seems to me that it would be appropriate to allow Mr. Ratterman to address that. In fact, I believe that the bench intended to ask Mr. Ratterman questions on those issues. Would anyone like to argue a contrary position on that point? Mr. Cooper.
Only what I said before. I mean, I think we should have the last say on issues because it's our burden. So if we can have an additional opportunity to file testimony on this issue, that would be appropriate, I think.
I guess I would add, Judge, if the bench had questions about those proposals for Mr. Ratterman, I think that allows Ms. Griffin to address it on redirect, but doing a direct right now, I still think would be kind of improper.
Okay, so that's one issue that you've raised, Ms. Griffin. Would you remind me of the other matters so that I can weigh this all out?
Yes, well, the other issue is obviously Missouri American has sought to add 2 new exhibits relating to this continuing authority issue, which also goes to just the authority in general of the district that is being challenged by both or questioned by staff and by Missouri American. And I felt it was only fair for us to be able to respond with additional information regarding what we believe the authority of the district is to fully make our record.
So are you referring to 2 exhibits that appear on Missouri American's proposed exhibit list but have not been offered at this time?
I'm referring to those exhibits. I'm also referring to portions of exhibits that we didn't go into detail with that were filed with the rebuttal testimony that, as the continuing authority is questioned in SIR rebuttal, that I think it's only fair that the district have a chance to respond to that and give its position on what its authority is. I mean, we've said the whole time that we've been involved in this proceeding that we believe we have long-term planning authority legal authority that poses an obstacle for this transaction. And obviously the staff and Missouri American have a different position, but now that they've volleyed this back, we feel like we won't have a complete record if we aren't allowed to put some additional evidence into the record.
Okay, so we've got an issue in regard to what Mr. Ratterman might want to tell us about other proposals that were identified in Sir rebuttal to upgrade the system, and then now additional information that you would like to offer in regard to continuing authority, which to some degree is prompted by some exhibits that the company has identified but not yet offered.
Well, Judge, just to clarify, continuing authority as well as authority of the district under its own regulations, which it is a part of this whole continuing authority. There's overlap in those issues. And those regulations are included in one of the schedules to Mr. Ratterman's testimony.
Okay, and are those the only issues that you were hoping to ask Mr. Ratterman to address at this time under questioning from you?
I believe those topics, yes, are encompassed by that. It's the continuing authority, the authority under the regulations that are part of that schedule, the boundaries of the district, which goes to our Exhibit 203 that was added to our exhibit list, and the treatment options that we discussed earlier.
Is there a reason why all of the evidence that you wanted to present as to continuing authority was not included in your rebuttal filing?
Yes, because they raised it in their rebuttal testimony and schedules. I mean, we're in a proceeding today, and Missouri American's being allowed to change a portion of its application, and I feel that it's only fair that we be allowed to respond to issues, matters that were raised in rebuttal.
You know, Judge, the continuing authority order or continuing authority issue was raised in rebuttal of the sewer district. So they certainly had an opportunity to discuss that issue. I believe treatment options to a great extent were addressed in our direct. So there was also the opportunity to address those in the rebuttal testimony.
Yeah, Judge, we had continuing authority in our staff rec that was also in our direct, and I guess a lot of the issues I'm hearing, it sounds more like this would relate more back to briefing than a need for a direct as to interpretation of the authority. Yeah, I guess I don't really see a reason for the direct right now. And if Missouri American Water were to use the exhibits they shared yesterday in a cross-examination of Mr. Rotterman, Ms. Griffin will have the chance to question him on those on redirect.
So as far as proposed exhibits that have not been offered, I don't think that we can use those at this point as a basis to say that an issue has been opened up. It's a different story if those exhibits are in fact used, as Mr. Pringle has just said. So I'm not persuaded that identifying potential documents on an exhibit list, which is what the commission asked these parties to do, should be relied upon before those exhibits are even offered to bring in issues that may be new issues. The district's contention as to continuing authority seems to me to have been present at the very start of the district's intervention in this case. At the same time, I think the commission should have the benefit of the information that is available to make a good decision. So I don't think that necessarily we should be overly concerned if every single thing wasn't identified at a certain point in the process, if in fact that would help guide a good commission decision. I believe that what I would prefer to do is to ask Ms. Griffin to proceed in the way that commission testimony typically proceeds, and to offer Mr. Ratterman's testimony and allow the other parties to engage in cross-examination. And as is always expected in commission proceedings, then questions come from the bench and those are responded to. And although this might be a little bit unconventional, I think what I would prefer to do is see where we end up at that point after we have gone through the ordinary process and everyone who has come to this hearing today prepared has asked all the questions that they are prepared to ask of Mr. Ratterman. I think it's possible that having done that, we may end up in a situation where the district has provided virtually all the information that they think they would like to put in front of the commission. So essentially what I'm asking the parties to do is table this issue for the moment. And I'm asking Ms. Griffin to proceed to offer Mr. Ratterman's testimony as it was filed and tender the witness for cross and see where cross goes and see where questions from the bench go. And then if we have a dispute at that point that has to be resolved about whether we need to use, to allow some additional questions that go into other areas, then we can take that up at that point. I think I can make a better decision when I have more information about what Mr. Ratterman is going to say on cross and what answers he has for the bench. Does anyone have any objection to that procedure? Okay. So I think where we would be now is, I believe Ms. Griffin would offer Mr. Ratterman's pre-filed testimony.
Yes, Judge. Mr. Ratterman, if I were to ask you the questions contained in Exhibit 200, would your answers be the same today as they are in Exhibit 200?
Yes.
And are those answers true and correct to the best of your knowledge and belief?
Yes.
Thank you, Mr. Ratterman. At this time, the district moves to enter Exhibit 200 into the record.
Thank you very much, Ms. Griffin. Are there any objections to District's Exhibit 200, which is Mr. Ratterman's pre-filed rebuttal testimony? All right, hearing none, Exhibit 200 will be admitted to the record. We can now proceed to any cross-examination of Mr. Ratterman, and we would start with staff.
Thank you, Judge. Good afternoon, Mr. Ratterman.
Good afternoon.
Now, how many sewer customers does the district currently serve?
About 7,200.
And how many wastewater treatment facilities does the district operate?
21.
Now, if the commission were to reject Missouri American Water's application for a CCN, that doesn't mean that the district would automatically get the city of Hallsville system, correct?
No.
Hallsville would continue to operate the system on its own as it has for years now, correct?
Offer it to Boone County Regional Sewer District.
So we did not get that answer. I apologize for interrupting. It appears Mr. Ratterman's connection is not great. So what I'm going to do is ask Mr. Ratterman if he can hear me. Could you disengage your video for us and just try to rely on audio? Sometimes that helps. And then I'm going to ask Mr. Pringle to repeat his question, and I apologize for that. Thank you.
Yeah, Mr. Rotterman, the question was, Hallsville could continue to operate the system on its own as it has for years, correct?
They could until they decide not to, in which case they would need to offer it to the Boone County Regional Sewer District.
And it's your position, Mr. Rotterman, that they have no choice but to offer to the district if they do not want to run their system. Is that correct?
Correct.
Now, has the district ever exercised its level 2 continuing authority to prevent the sale of a municipally owned system to a different service provider?
No.
And the district also did enter a proposal to purchase the system from Hallsville, correct?
Yes.
But in the end, the city chose Missouri American Water over the district. Is that correct?
It appears that way.
All right. Thank you, Mr. Rotterman. I have no further questions.
Thank you. We can proceed to any cross-examination from Missouri American.
Thank you, Judge. Sir, could you pull up Schedule TR-1, Part 4 from your rebuttal testimony?
Schedule TR-1, Part 4.
Correct.
Yes, I have.
Okay, and the first page is marked page 161 of 213, correct?
Yes.
And is that a listing of, I guess, both past, actual, and projected future rates for the district?
It is an excerpt from a user rate study. You're talking about this very first page,
161?
Yes, it is an excerpt from a use.
Okay, so if I look at the top bar, I guess there's a rate A actual that starts in 2018. Does that mean that those were the district's actual rates in 2017 and 2018?
I would have to go back and verify that.
Okay. Well, look at the year 2021. There is a total charge listed of $65.91. Is that the current district rate?
It is. Yes.
Would you also turn to Schedule TR5 and then page 2 of 2? And let me know when you're there.
I'm there.
Okay. At the top of that, near the top, well, first off, there's a yellow line across that page, correct?
Correct.
And at the top of that line, it's marked Cedar Gate WWTF, correct?
Correct.
And at the other end of that yellow line, it says gravity sewer connection. Is that correct?
Correct.
And is the gravity sewer connection close to the, I guess, what's been referred to as the Rocky Fork wastewater treatment facility?
I would say it's about 2 miles away, but the red dot labeled gravity sewer connection, from that red dot, there is a gravity sewer all the way to the Rocky Fork wastewater treatment plant.
Okay. And that's in existence today, I take it, right?
Correct.
If I go back up to the top of that sheet and I look at the portion of the line from Cedar Gate to Richardson Acres, is that line in service and in use today?
It is not.
Was that line contemplated in the district's facility plan prior to the December 10, 2020 amendment?
No, it was not. It was prompted by permit negotiations with DNR on Cedar Gate.
So you being the district has a problem with the Cedar Gate wastewater treatment facility that it needs to address. Is that accurate?
I wouldn't call it a problem, but we have a compliance schedule to come into compliance with ammonia and E. coli, we have a compliance schedule in our permit.
Now, I mentioned the December 10, 2020 amendment to the facility plan. Has that amendment been approved by the Clean Water Commission as of today?
No.
Now, also looking at
let me go back to that a second.
Go ahead.
You asked if it's been approved by the Clean Water Commission. These facility plans, the approval is by the department itself, usually in the form of a finding of no significant impact or a categorical exclusion.
Which would be different than approval by the Clean Water Commission?
If my memory serves me, what we get is a letter from the Department of Natural Resources approving the facility plan.
Do they not have
concluding usually that it's a finding of no significant impact.
But again, I guess my question is that something different than approval by the Clean Water Commission?
I don't know that I'm qualified to answer that. If an approval by DNR staff is different than an approval by the DNR Clean Water Commission, I don't know that I'm qualified to answer that.
Yeah, so I take it you just don't know the answer to my question. Is that accurate?
Okay, yeah.
Okay. Now, again, looking at our this map that's on the that we started in talking about, there's another section of this line that goes from about the Richardson Acres WWTF down to the Brown Station booster pump station or Brown Station WWTF. Is that portion of the line in service and in use today?
No, it is not.
And then the same question, the portion of the line from Brown Station WWTF to the gravity sewer connection we talked about earlier, is that portion of the line in service and in use today?
No, it is not.
We talked a little bit about the need to address some issues with Cedar Gate. Does the district also have a need to address issues with Richardson Acres and the Brown Station WWTF?
We do. We have a compliance schedule on the Richardson Acres permit that requires ammonia removal and E. coli removal. We also have a compliance schedule on the Brown Station permit that requires a lower ammonia limit and E. coli removal.
And those problems or those issues need to be addressed one way or another, whether Hallsville sells its system to Missouri American or not, correct?
Yes.
And do I understand from your amended facility plan that the means of financing improvements described in that document is proposed to be use of the state revolving fund?
That's one option.
My memory is that's the option that was identified in the facility plan. Were there other options identified in the facility plan?
I would agree. That is the only option identified in the facility plan.
Now, in looking at your resume, it appears that, well, I think you've been employed with the district since about March of 2004. Is that correct?
Yes.
And were you the general manager of the district even prior to that March of 2004 date?
I was.
How long before, when did you start as general manager of the district?
It was either 1999 or 2000. It's 2000, I believe.
And would you have been involved with the district's application for the level 2 continuing authority that's been discussed here today?
Yes.
And before seeking that authority, did the district first go to the Boone County Commission to get its support for that application?
I would say we did it simultaneously.
And is it accurate that the Boone County Commission issued an order providing support for that application?
Yes.
And do you have with you Missouri American Exhibit 5?
I do.
And it's a document, correct, that's identified certified copy of order at the top. Is that what you're looking at?
I have it. It's a Commission Order 353-2009.
Great, thank you. And is this a copy of the order issued by the Boone County Commission in support of the level 2 continuing authority application?
Yes.
And if you would look near the bottom of page 1 of that document, there's a sort of a subheading that says resolution. Do you see that?
I do.
Would you agree with me that it states it is therefore resolved by the Boone County Commission to support the Boone County Regional Sewer District and the City of Columbia in filing a joint application for Tier 2 continuing authority with the Clean Water Commission for the Clean Water Commission's approval, period. The application shall request that the Boone County Regional Sewer District be approved by the Clean Water Commission as the Tier 2 continuing authority in unincorporated Boone County, and that the City of Columbia be approved by the Clean Water Commission as the Tier 2 continuing authority inside the corporate limits of City of Columbia.
I would agree that that's what it says.
Okay. Are you familiar with a person by the name of Leslie Oswald?
I am.
And who would that be?
She retired as the finance manager of the Boone County Regional Sewer District on March 31st of this year.
Would she have been involved in the effort to get the Boone County Commission's support for the Tier 2 authority application?
Yes.
And I assume there would have been a meeting before the Boone County Commission where that request for support was discussed by the commission. Would that be accurate?
Yes.
Did you attend that meeting?
I don't know.
Okay.
That was a long time ago.
Would you look at Exhibit 6 if you have that before you?
I do. I have it.
And on page 2, there at the very top, it starts Leslie Oswald, Boone County Regional Sewer District. Do you see that?
I do.
Have you had a chance to read that portion of the document? And let me know after you've read that.
I've read it.
Okay. Does that refresh your recollection of that meeting, or whether you were in attendance at that meeting?
I don't know if I was in attendance. But it You hear
I'm
me?
sorry, did he answer? I just heard but it.
I think that your line is cutting out, Mr. Ratterman, so if you want to start over and try to answer that question again, please.
It does refresh my memory.
And would you say that the minutes, well, let's back up just a second. Would you agree with me that these are Boone County Commission minutes from 30 July 2009?
Yes.
And would that description of Ms. Oswald's presentation to the commission be consistent with your memory?
Yes, but we use that term unincorporated area as a generic term. When people call in and ask us where we serve, when a customer calls on the phone, it's easy to explain to them that we serve the unincorporated areas of the county. And in that manner, it's a generic term.
Okay. So looking again at that document, would you agree with me that the first paragraph indicates that Ms. Oswald stated the BCRSD and the city are both going to the Clean Water Commission to ask for Tier 2 continuing authority for specific territories? She stated the city's territory would be the city limits, and the BCRSD territory would be the entire county and the unincorporated areas. She stated we would not have authority in the small municipalities. Is that correct?
That's what the minutes say, yes.
Okay. Judge, at this time, I would offer Exhibit 5 and Exhibit 6 into evidence.
Thank you. Is there any objection to the company's exhibits marked 5 and 6? Mr. Pringle has indicated no objection, and Ms. Griffin?
No objection, Judge.
Hearing no objections, those exhibits will be admitted to the record.
Thank you, Judge. That's all the questions I have at this time.
Thank you. The floor would now be open for any questions from the bench. If we have questions from commissioners, they will speak up. If a commissioner has joined us by telephone, I apologize. I did have to silence or mute some of the phone connections. If you're having difficulty getting through, you might press *6 to unmute yourselves, and or otherwise have someone send me a message and let me know you're trying to get through. So, Mr. Ratterman, I wanted to ask you about the district's agreements with the city of Hallsville concerning the Silver Creek and Sunny Slope subdivisions. And earlier in this hearing, the documents that I'm referring to were admitted to the record. And if you have access to the file record in this case, you would find them in the August 31st, 2020 filing by the company. They were marked as Appendix E and Appendix F. Mr. Ratterman, can you confirm whether you're able to consult those documents?
Can you give me that date again?
Yes. August 31st, 2020, I believe was the filing date. And it's actually a company filing, so it was a Missouri American filing. Everything is all together in one document, so the appendices are not broken out into separate attachments. You'll just be opening one PDF.
Yes, I'm there.
Okay, and it looks like Appendix E starts on page 13. So that's an ordinance. And then do you see the next document, the cooperative agreement?
I do.
And to confirm that we're talking about the same thing, which subdivision does that agreement concern?
This one refers to Sunny Slope.
Okay, and it appears if you scroll down to the signature page, this is not the agreement that you had signed, but I believe that you're a signatory, or are you a signatory to the Silver Creek agreement?
Yes, I signed Silver Creek.
Are you familiar with both of these agreements?
I am.
Okay. Can you tell us if any district customers are currently receiving services from the City of Hallsville sewer system in Sunny Slope?
They are not. There are none.
And in Silver Creek?
I believe it's 3 or 4.
Previous testimony had indicated that these agreements call for some payments to be made to the city by the district to connect customers. Have payments been made under these agreements?
I believe that if you look at Sunny Slope, I think it was paragraph 10 that we talked about earlier. I believe we made this payment for Sunny Slope.
So no customers are being served in Sunny Slope, but the $5,100 one-time connection charge has been paid to the city?
I mean, I would have to verify it, but paragraph 10 says this one-time connection charge shall be paid contemporaneous with the signing of this agreement. I believe we took care of this.
Were there some actual modifications that needed to be made to put this agreement into effect so that customers could be served at Sunny Slope? So actual construction changes or changes in that sewer system for that subdivision?
Yes, I would refer you to Exhibit A of this agreement. We've labeled the approximate location of the existing Hallsville gravity sewer as point C. We would have to build a sewer from point C to point E.
And do you know if that has been done?
That has not been done.
Okay, so your testimony as to whether a payment was made, I didn't think was definitive. You believe it would have been taken care of contemporaneously, but are you confident that that happened?
Yes, I'm confident that happened.
And your testimony is also that the actual physical connection, the construction work that would have to be done, that has not been done.
Correct.
And no district customers are currently being served in Sunny Slope with sewer connection to the city of Hallsville. Is that correct?
That is correct.
Okay. So moving over to Silver Creek, you previously testified you thought 3 or 4 customers are being served. Would that be 3 or 4 lots within that subdivision that have a connection to Hallsville and service through Hallsville?
Yes.
Okay. And I would ask you if a payment has been made under the Silver Creek agreement to the city?
I don't know for certain.
And do you know if any, well, first of all, is any construction work, modification of the sewer system, or any new installation required for the Silver Creek agreement?
Yes,
And is that also depicted on the map that's attached as Exhibit A to that agreement?
it is not.
It is not. Can you describe it to, can you describe that work to us? Potentially with reference to the agreement, if you can find the location in the agreement.
Oh yeah, give me a second. Well, paragraph 2 and paragraph 3 refer to it. Paragraph 2 refers to the connecting sewer. Means the sewer connecting the Silver Creek subdivision to the cities of Hallsville's collection system. And then 3 says the developer shall prepare the plans and specifications for construction of the connecting sewer.
Is it your understanding that that work has been completed?
Yes,
Is the Silver Creek subdivision a new subdivision such that new homes are being constructed on lots there?
yes,
I think we previously were told that the Sunny Slope subdivision, on the other hand, was an existing subdivision that already had homes and there wasn't new development taking place. Is that your understanding?
yes. I would say Sunny Slope has been in existence for at least 40 years.
Are these subdivisions residential subdivisions made up of single family homes?
Yes,
And are you able to give us a sense for the number of lots in the different subdivisions? Do you know the lots in Sunny Slope?
I believe the agreement says 17, and I believe that is correct.
Could you remind me of which paragraph we can find that reference in? Thank you.
It is also in paragraph 10. There's a reference to 17 units.
And then Silver Creek. Does that agreement also tell us how many lots are in that subdivision? Yes, I think it does. I found it in the, do you see the whereas paragraph on the first page?
Yes.
And what does that tell us?
It references 7 single-family lots. It's also in paragraph 2.
Thank you. So why did the district enter into the agreement regarding Sunny Slope with the city?
We knew that there were regulations coming from DNR that would require disinfection and ammonia removal. And the current treatment facility, there's not sufficient land area there to improve the facility. And there was a existing gravity sewer owned, operated, and maintained by the city of Hallsville. About, if you look at Exhibit A, that map is to scale. I would say we have to build about 400 feet of sewer to connect to the city of Hallsville. And we commissioned a facility plan by a consulting engineer. We looked at all options, and the connection to the city of Hallsville was best for the environment and best economically.
So is Sunny Slope, is it a lagoon system that's in place for Sunny Slope through the district?
Yes, it is.
And is that lagoon system still operational?
Yes, it is.
So it is being used at this time?
Yes, it is.
And could it be used in the future for the existing homes?
It could, yes.
Okay.
As I mentioned earlier, there's a compliance schedule on that Missouri State operating permit.
So the performance of that system is going to have to change in the future, and making that possible may be challenging under current conditions. So the desirable outcome was to just hook up to Hallsville. Do I understand you correctly?
Yes.
Okay. And can you tell me about why the district entered into an agreement with Hallsville for the Silver Creek subdivision, which is a new development?
Yes. This was proposed by a real estate developer, and the real estate developer wanted these lots to be served with public sewer. And this is not contiguous to the city limits, and cities cannot provide sanitary sewer service outside their city limits without the consent of the sewer district. And because of that, we worked out this connection agreement between the city of Hallsville and the sewer district for this subdivision.
Is it your understanding that as additional lots are developed in Silver Creek under this agreement, they will be able to continue to connect and get service from the Hallsville system?
Yes, that's the way I interpret this agreement.
And if the district had not agreed to consent to connection to the city sewer system, what would have been the options for that developer and the developer's essentially customers buying homes out there?
That's a little more complicated answer. Boone County has a zoning ordinance and subdivision regulations, and Boone County Health Department also gets involved in these matters. And the best answer that I have is that it's a collaborative approach between County of Boone through its Boone County Resource Management Department implementing the zoning ordinance and the subdivision regulations, and the Boone County Health Department and the Boone County Regional Sewer District to require developers to put in public sewers where it's best.
Does the district's status as a continuing authority in the county mean that those folks who bought homes in that development would have had to be district sewer customers? Or could they have put in a private sewer?
So the sewer district has regulations that define 4 different classes of sewer systems: public sewer systems, private common collectors, private sewer systems, and private on-site wastewater systems.
And I believe that you just told us that this development would have been required to put in a public sewer system. Is that correct?
Yes.
And is that because of the provisions of the district's own regulations?
That, and it was the developer's desire to serve these lots with public sewer.
Okay, I think that's probably as detailed as we need to be on that particular point. Is there anything else that you think the commission needs to understand about that?
No, I don't think so.
What are the consequences for the district's customers in Sunny Slope and Silver Creek if Missouri American does not assume the city's obligation under those agreements, or if the district and the company are not able to reach new agreements?
Well, what these agreements, the way I read these agreements, the city of Hallsville has an obligation to provide service to these 7 lots in Silver Creek and the 17 lots in Sunny Slope. And if the city of Hallsville does not honor its obligations, Sewer District Board of Trustees would have to decide how it's going to enforce these 2 contracts.
So my question was actually a little bit more pragmatic than a legal question. So you've already told us that the Sunny Slope folks have a lagoon there that's in place that, although it isn't potentially going to comply with regulation here in the future, it's in place and has been used to serve those residences in that subdivision.
So if you're asking what the technical options are at Sunny Slope, the sewer district does have the ability to acquire land, and the sewer district could acquire sufficient land to build some kind of treatment system to keep Sunny Slope into compliance with DNR regulations.
And then is there a different situation for Silver Creek because it was built to connect with Hallsville?
I would think so. I mean, there is a pipe running from these 7 lots connecting to a pipe that is currently owned by the city of Hallsville. If the sewer district, I would have no intention of disconnecting that pipe. If somebody else tries to disconnect that pipe, we'd have to have some kind of conversation about that.
I have a question for you about staff's recommendation in this case concerning a requirement that the company negotiate with the district in regard to Sunny Slope and Silver Creek. And my question is, does it make sense to you that that negotiation process start after any permit is issued by DNR?
No, I think these agreements, if need to be worked out and resolved before a conveyance is made between the city of Hallsville and Missouri American, if that's what's going to happen.
And could you explain why?
Because as a business, the sewer district needs certainty in its operations.
Okay, I want to ask you about your testimony on page 10 that indicates a major goal of the plan is to eliminate existing wastewater treatment facilities within Boone County.
Okay, can you, what plan, or is this the facility plan?
So on page 10 of your testimony, we can find that, and then you can, part of my question is exactly the plan that you are talking about. So it appears that you have referenced multiple facility plans for defined areas in Boone County. So this appears to begin on line 5 and run through line 12.
Hang on a second. Can you give me a date on that?
Your rebuttal testimony was filed on February 23rd, I believe.
Thank you.
Sure. And this appears on page 10.
Okay, I'm on page 10.
Okay, so beginning on line 5 through page 12, that's the passage I was referring to, and I was focusing on your statement in regard to the goal of eliminating wastewater treatment facilities in the county.
Okay.
So here, the plans that you're referencing are facility plans?
Correct. Facility plans and capital improvement plans that we have developed over the years.
And I believe that attached as a schedule is one of these plans as TR1. And it's the attachment that is very large, so it was made in multiple parts.
Yes.
Okay, so that's the Boone County Regional Sewer District Facility Plan for the Richardson Acres and Brown Station wastewater improvements. It's indicated that it's an Amendment 1.
Yes.
Okay, so your statement that, once again, to go back to my question, you've indicated that a goal of the plan, so when you're referring to the plan here, you're referring to all of the district's facility plans collectively, or what are you referring to?
Yes, all of the facility plans that the sewer districts commissioned over the years.
Okay.
Including
And I cut you off there. I believe you were saying all of the plans, including this one.
Yes, that's correct.
Okay. And so first, I just wanted to ask you, what does this goal mean? Elimination of wastewater treatment facilities. Your testimony indicates the district owns 21 facilities. Does that mean the goal is to get rid of all of them and centralize wastewater treatment and disposal? Just explain that, please.
So the sewer district has these 21 treatment facilities in the county. Prior to anti-degradation, prior to disinfection, real estate developers, if they were creating developments that were dense enough, were required to put in public sewers and treatment facilities. And between Boone County zoning ordinance and the Boone County subdivision regulations and the sewer district's own regulations, these facilities were required to be conveyed to the sewer district in much the same way that the roads are required to be conveyed to the county and the water lines are required to be conveyed to the rural water districts. And as these facilities age and there's a need to modernize them. The sewer district works to consolidate these treatment facilities in different locations. A good example is this Rocky Fork wastewater treatment facility that we're talking about. When we built that, we took out the Rayfield Lagoon, Bongor Lagoon, County Downs Lagoon, Powell Lagoon, Benora Lagoon, and the Wagon Trail Lagoon. And since that time, there's been private DNR permitted facilities that have also connected. Some of these developments, like I mentioned before, Sunny Slope, actually, I believe Sunny Slope was built in about 1971. So some of these are almost legacy issues from either before Boone County had planning and zoning or in the right after Boone County got planning and zoning, and these things were still being created. To give you a little more history about the sewer district, some of these facilities, the developers conveyed them to neighborhood associations. And some of them, the developers conveyed them to a PSC regulated company that was called Mid-Missouri Sanitation. And in about the late 80s, the county commission conveyed about 15 of these facilities that neighborhood associations had given to the county commission. County commission conveyed them to the sewer district, and the sewer district bought out the old Mid-Missouri Sanitation Company. And that's how the sewer district became operational in the late 80s. We acquired about 30 facilities all at one time and became operational. And since that time, our capital improvement plans have revolved around regionalization and either building treatment on our own and consolidating these facilities and serving new growth, or in some instances, connecting them to the city of Columbia or city of Hallsville.
So, trying to summarize what you just shared with us, it sounds as though the district strategy has been to connect to municipal systems or establish treatment systems to centralize other smaller systems.
Yes, I think that's an accurate representation.
So I have a question for you about the facility plan that is attached to your testimony, which we just went through the process of locating together. It's TR1, and I believe it has a date of December 10, 2020 on it.
Yes.
So, and that plan talks about connecting Hallsville essentially to the Rocky Fork treatment facility. Is that right?
Yes.
Okay. So is there a previous draft of the plan that does that, or was that introduced in the December 2020 draft?
It was introduced in the December 2020 draft.
So at the point when we've heard testimony that the district also made an offer to the city of Hallsville to acquire that system.
Yes.
At that time, was the district proposing to transport Hallsville waste to Rocky Forks?
Yes.
But that plan did not appear in a facility plan yet?
Correct.
And is there a reason why it did not?
Well, two reasons. One is that City of Hallsville issued a request for proposal to sell their wastewater system. And as part of our developing our proposal to the city of Hallsville, we wanted to develop a plan to solve the problem. And so we commissioned our consulting engineer to make this amendment. The second reason is, so we've talked about these 21 wastewater treatment facilities that Boone County owns and operates. At one time, not too long ago, all of the operating permits, with one or two exceptions, were expired. And we were in a lengthy negotiation with Missouri Department of Natural Resources to renegotiate these, to get these permits issued so that we would have some certainty in our business operation. And Cedar Gate was reissued, and it had a compliance schedule for coming into compliance with ammonia and E. coli. Our original plan for Brown Station and Richardson Acres was to connect to the city of Columbia, but our connection agreement with the city of Columbia did not include Cedar Gate. So it became apparent that we weren't going to be able to connect Cedar Gate to Hallsville. So we revised this plan to connect Cedar Gate to Richardson Acres, to Brown Station, to Rocky Fork, and to serve Hallsville. And I might add, we also have another treatment facility. If you look at, go back to Schedule TR5, first page, and you look to the west of the Hallsville city limits, you'll see another sewer district facility called Quarter Mile Hills. It too has a compliance schedule for ammonia and E. coli. So the revision of this plan served many purposes.
Okay, and I want to clarify something because I believe that a previous draft of the facility plan was attached to a district filing in September. And so I want to make sure that that is consistent with what you have just told us, so that if a clarification is needed, we could take care of that right now. So it looks like September 8th of 2020, the district filed a reply to the company's opposition to intervention, and that included as Appendix A draft facility plan dated August 10th of 2020. Will you let me know when you can find that, Mr. Ratterman? I can give you dates again if it's helpful.
Yeah, if you can give me the date again, that would be helpful, please.
It's September 8th, 2020, and this is a district filing, and you'll be looking at Appendix A.
Okay, I'm looking at that. So, okay, I'm ready. What's the question?
Okay, so this particular plan is dated August 10th, 2020. Can you tell me what the difference is between this plan and the one that was attached to your testimony?
Yes. So the August 10th, 2020 version just included Richardson Acres, Brown Station, Cedar Gate, and the private DNR permitted facilities along the route. December 10th, 2020 version included Hallsville.
So included the proposal to take Hallsville waste, I guess, from Cedar Gate, then all the way down to Rocky Flats. Am I understanding that correctly?
Yes.
Okay. So this particular attachment that I've identified, everyone, I would propose that it be admitted to the record as Commission's Exhibit 307 to help me understand Mr. Ratterman's testimony. Does anyone have an objection? That would be Appendix A to the district's filing on September 8th, 2020. I'm hearing no objections, so that will be admitted to the record as Commission's Exhibit 307. Okay, I wanted to ask you, Mr. Ratterman, about how these facility plans are reviewed, if at all. So your testimony attaches a facility plan with the date of December 2020. You were previously asked about whether it's been approved by the Clean Water Commission, which developed into your testimony that in fact it would be the Department of Natural Resources that would approve it in your understanding. So my question for you is in regard to the December facility plan that's attached to your testimony, has that been submitted to DNR for review of any kind?
It has, yes.
Okay, and how long does that review typically take? And when do you know if you have a problem?
You know, that schedule is somewhat DNR's and somewhat the sewer districts. I have been meeting with DNR on this project and others. One of the things we're working on is phasing. I had a meeting with DNR where we talked about whether they would approve this plan in phases. And I got an email back from one of the review engineers that they were amenable to approving this in phases.
So it sounds like there's no rule or regulation that provides that it needs to be reviewed and approved within a specific period of time.
Not that I'm aware of.
Okay, it's more of a consultation process with DNR.
Yeah, I think that's an accurate representation.
Okay. So I wanted to ask you, what is the relationship between the facility plans that we've been looking at and what DNR's regulations refer to as an area-wide management plan? And there's reference to area-wide management plans in 10 CSR 20-6.010. So I guess I'll simplify this a little bit, Mr. Ratterman. Are you familiar with the term area-wide management plan?
Yes.
And what does that mean to you?
So you just cited some of the Code of State regulations, correct?
Yes, I did. I was citing the state regulations. That's right.
And is that the Code of State regulations that refers to continuing authorities?
Yes, it's 6.010 construction and operating permits. And it's actually in Part 2C is where there's a reference to area-wide management plan.
So
approved. Yeah, go ahead. I apologize.
When the sewer district and the city of Columbia, my recollection is that when we applied to the Clean Water Commission for level 2.
Judge, I think the court reporter is trying to get your attention.
Yes, go ahead, ma'am. Okay, court reporter.
Yes, I was trying to get someone's attention, but if I can't make noise, the screen doesn't come up for me. I got where he asked you, is that the code of state regulations? Is that right? And you said, yes, that is. And then nothing after that.
Okay, so we will just pick up where that left off.
Okay.
And I clarified that I'm looking at 10 CSR 20-6.010. And I had asked Mr. Ratterman if he recognizes the term area-wide management plan and if that means anything to him, and he may now answer that question. Thank you.
So my recollection, when the sewer district and the city of Columbia made application to the Clean Water Commission for level 2 continuing authority, that we both had capital improvement plans, and those are more of a sketch plan than a facility plan. A facility plan gets into 3 or 4 alternatives and lots of narrative and such things. A capital improvement plan is usually a summation of projects and a cost estimate for each project based on judgment as to what is the most likely project. And my recollection is that those capital improvement plans were part of the application to the Clean Water Commission when we applied for level 2 authority. And we had to show that we had a plan for all of Boone County. And it's that the sewer district collaborates with the Boone County Commission and the Boone County Resource Management Department in the implementation of the zoning ordinance and the subdivision regulations. And we did the other.
I'm sorry, you cut out after "and we."
And the other municipalities of Boone County were not included because, in part, because there's so many of them.
I think we're going off course of what my question was. So is there a document that you're aware of that has been provided to the commission, in this case, that constitutes an area-wide management plan that's been prepared by the district?
You're talking about the Clean Water Commission now, right?
I'm talking about the commission that you're before right now. Is there a document that has been provided that constitutes an area-wide management plan that's been provided in this case?
No, I do not believe so.
Okay. Okay, I'm going to ask you about another feature of your testimony on pages 11 and 12. You talk about how Hallsville's sewer system is upstream from the district's facilities and that its operation and management impacts the district's plans for wastewater treatment and the rates charged to district ratepayers. I wanted to ask you to explain your testimony in further detail.
Okay, so if you look at the City of Hallsville's operating permit, there are several permitted features. And some of those permitted features are in the Varnon Branch watershed. And the Cedar Gate facility is also in the Varnon Branch watershed. And the Varnon Branch is tributary to the Hinkson Creek. And the Hinkson Creek is listed on what's known as the 303D list. And it's on the 303D list because it's an impaired water. The 303D list is the list of impaired waters in the state of Missouri. And if the sewer district has to make improvements to facilities in the Hinkson Creek watershed, that affects our customers and our customers' rates. And if the Hallsville facility is contributing to the impairment in the Varnon Branch and the Hinkson Creek, that affects sewer district customers and sewer district rates.
Okay, thank you. I also wanted to ask you about the opinion you provide in your testimony on page 14, in which you say that adding treatment to the Hallsville system is not adequate, and that's a paraphrase, because, quote, it will not resolve the capacity issue or ongoing violations. So my question for you is, why would adding treatment not address ongoing violations in the Hallsville system?
Well, when I read the city of Hallsville's RFP, and I read their permit and the design flow of their permit and the actual flow listed on their permit and the number of subdivisions and the number of lots that they've approved in the city of Hallsville, the load from what they've approved exceeds their design flow. So just making an improvement without an expansion does not solve their problem.
And this raises another question I had for you. When an operator goes to DNR for a permit, is the need for expansion something that DNR considers in granting a permit?
Well, it's good engineering practice when you're proposing to make a capital expenditure that you consider the design life of the facility, and you know what the existing load is to the facility, and you can project the 20-year load on the facility. Whether you project you're forced to project the population 20 years into the future, and build a facility and expend capital funds that meet the 20-year design life of the facility.
So if that's good engineering practice, is that the kind of thing that the Department of Natural Resources expects to see in permit applications?
Well, I don't really know what the DNR expects, but I would say yes.
Okay, I wanted to ask you about a cost estimate that is included in your rebuttal testimony on pages 15 through 16. And I believe here you're summarizing a $3.5 million cost for a force main and associated pump stations. And this is to go from, I'm sorry, excuse me, from Cedar Gate wastewater treatment facility to Rocky Fork. And I just had a question about one element of that estimate so that it wouldn't potentially be stated incorrectly. The $694,500, I wasn't clear from the way that was written whether that is an ongoing cost or a construction cost. It indicates it's associated with pumping the flow from Hallsville's storage lagoon to Cedar Gate.
I'm sorry, I'm new to this Public Service Commission. Can you help me and tell me where this is, what you're looking at?
Yes, and I'm sorry if I went too quickly for you. This is your testimony. I believe it runs from pages 15 to 16. It's your rebuttal testimony.
I lost it on EFS. Can you
That's
give me
okay. Yes, it's February 23rd, sir.
of,
February 23rd, 2021.
thank you.
And pages 15 to 16 is what my notes indicate. So it starts at the bottom of 15.
Can you repeat your question, please?
Yes, I can. My question concerns the statement about the $694,500 part of the estimate, and that's in line 1 on page 16. And the testimony states that that amount is associated with pumping the flow from Hallsville Storage Lagoon to Cedar Gate. So I couldn't tell from that if that is construction cost or what kind of cost that is.
That is a capital expenditure, construction, engineering, land acquisition, easement
Okay.
acquisition.
Okay,
That is
thank you. I think because of the terminology pumping the flow, I didn't know if that was an ongoing cost. It seemed pretty high, but I'm just clarifying that. Thank you. Okay. You have also indicated on page 15 of your testimony, and let's see if I can find this. Yes, you've stated that you have some concern about the company, Missouri American, adopting the rates charged in the Hallsville system initially. And I just wondered if you could elaborate on what your concern is there with the adoption of the current rates that the Hallsville is charging.
Well, that there would be losses to Missouri American. I don't understand how how it can be in the best interest of the public to not have a plan and not know what it's going to cost and not know what it's going to cost to the ratepayers.
And we have learned today in testimony that there is a proposal to increase Hallsville's rates, and that if I understand the company correctly at this time, the company is asking to apply whatever Hallsville's current rates are if a certificate is granted. Do you have any response in that regard? It would apparently mean an increase for some of Hallsville's customers and would overall, according to Mayor Carter, bring in more money for the system.
Well, I think what I heard in previous testimony today was that they are proposing a flat rate as opposed to a volumetric rate. And to me, volumetric rates are much more equitable to customer, especially the low income customer that may use 1,000 gallons or 2,000 gallons or 3,000 gallons a month. The sewer district uses volumetric rates.
So I think earlier we heard testimony from you about a rate, your base rate apparently in the district currently. And I believe it was, could you remind me what that was?
Yes, our base rate right now is $26.65.
What was the $65.91 that I heard, or maybe I wrote that down wrong?
No, you heard that right.
What is that?
That's normalized to a 5,000 gallon a month user. Our rates, our base service fee is $26.65. Our water usage charge is $7.85 per thousand.
Is that information included in any attachments to your testimony? Do you happen to know?
I don't. I'm sorry.
Okay. I know that the initial testimony that was drawn out of with Mr. Cooper was in reference to something attached. So perhaps Mr. Cooper knows where that is.
It was in a user. It was in a user rate study.
Okay. And Mr. Cooper, please go ahead.
Yeah, we can point. It's in a schedule to Mr. Ratterman's testimony.
Okay, I'm sorry. I just hadn't noted that before, and I missed making the notations when you went through it the first time.
It's in TR-1, Part 4.
Okay, thank you.
Mm-hmm.
So, Mr. Ratterman, I am getting very close to my last few questions. Is everyone able to proceed through these questions now, or do we need a quick break? All right, nobody's begging, so we will keep going. I think that applies to our court reporter as well. Okay. I have a question for you about the proposed conditions that the district has asked for in the alternative if the commission were to approve a certificate. So is there a reason why the district would request that Missouri American be required to actually acquire land to be used for the application of wastewater?
Yes, from my study of the system, when Hallsville issued its request for proposal, it became apparent to me that part of their problem is their farmer partner doesn't irrigate during wet years, and they're not able. So a spray irrigation system like that is not supposed to irrigate about 6 months out of the year. So they have to have enough storage to hold it for 6 months. And that means they have to draw down their storage lagoon in the fall and hold the water until the spring and summer when they can start irrigating again. And if they can't irrigate enough in the late spring, summer, and early fall, then they can't hold it through the fall and winter and early spring, and they start discharging. And it's a no discharge facility. They're not supposed to discharge. And that's one of their compliance problems. And if they owned the land and controlled the irrigation, they would be better situated to get rid of the water before winter.
Can you tell us why the district has requested that if the commission were to grant a certificate, the commission prohibit the company from converting the Hallsville system to a discharge system?
It goes exactly to the sewer district's planning authority. The sewer district is the wastewater planning authority for all of Boone County. And, you know, Mr. Williams referred to anti-degradation earlier. And one of the concepts in anti-degradation is that streams have an assimilative capacity to assimilate waste. And if Hallsville is discharging, they are using the assimilative capacity of the streams of Boone County, and that's under the purview of the sewer district to manage and make sure that it's there for all the residents and ratepayers of Boone County.
Does the district have agreements at this time with any other private sewer operators in the county that require district approval for DNR applications?
Well, that's not really the way it works. We have been asked by DNR to work with private owner operators of wastewater systems to get them to connect to us. I have an email in the last 2 months from a permit writer in the Macon, Missouri office, inquiring about 3 different private wastewater facilities in Boone County that are regulated by the Missouri Department of Natural Resources. And it's a collaborative effort between DNR and the sewer district to get these, to eliminate these private discharges of wastewater.
Okay, Mr. Ratterman, I thank you very much for your patience with my many questions this afternoon. Those are all the questions from the bench unless we have anything coming in from commissioners. So I believe we can go ahead to recross if there's any recross from staff.
Nothing from staff, Judge. Thank you.
Does Missouri American have any recross?
No, I don't believe so, Judge.
Thank you very much. Any redirect by the district, Ms. Griffin?
Yes, Judge, thank you. Guess I start at the end. Mr. Ratterman, you were just explaining in response to a question about the collaborative effort between DNR and the district to eliminate private plants. Is the authority for that effort, for lack of a better way to express it, predicated on multiple sets of regulations? And by that I mean state regulations, the district's regulations, and this grant of level 2 continuing authority?
Yes.
And under the district's regulations, are private plants allowed within the boundaries of the district?
No, they are prohibited.
Okay. And are municipally owned facilities subject to the district's regulations?
No, they are not.
Okay. And so, if I understand your testimony correctly, right now, the Hallsville system, because it's owned and operated by a municipality, would not be subject to the district's regulations.
That is correct.
And what is the impact of the sale of that system to Missouri American under the district's regulations?
Well, the impact is it would convert it from a public system to a private facility, subject to the district's regulations.
And is that regulation and regulatory authority outside of the level 2 continuing authority?
Yes, it is.
And when you were asked about the district's planning authority, does that authority that you reference include authority under the district's regulations as well as the state regulations?
I'm sorry, can you repeat that?
Yes, and you were asked some questions about the district's planning authority, and my question is it the district's position that that authority is derived from both the district's own regulations as well as DNR regulations?
Yes.
And you were asked, one of the first questions you were asked was about authority, and I don't remember exactly how Mr. Pringle phrased the question, but it had to do with whether there was authority for Hallsville to sell its system to Missouri American or Missouri American to purchase that system from Hallsville. And the response that you gave to that question was Hallsville must offer the system to the district. And I would like for the commission to understand the basis for the district's position that that is the case. Can you explain that?
Yes, it goes to the classes of sewer systems. Private sewer systems in Boone County are prohibited. And when municipal governments transfer something to, when they privatize, before they can privatize, they have to offer it to the sewer district. And if the sewer district is willing and able to own, operate it, and maintain it, then the sewer district will own, operate it, and maintain it. So if a municipality ceases to own and operate their own system, before they can privatize, they have to offer it to the sewer district.
And has this happened before? Does the district currently own or operate any wastewater treatment systems that were previously municipal systems?
The city of Rocheport conveyed its wastewater treatment and collection system to the Boone County Regional Sewer District.
And does the district operate any other systems that are owned by any municipalities?
We operate the Village of Hartsburg's wastewater treatment and collection system.
And is this the first time and that this situation of the prospective purchase of the Hallsville system by Missouri American, a sewer company that's regulated by this commission that we're in front of here today, is this the first time that type of a situation has arisen in Boone County?
To my knowledge, yes.
And if a situation like this had come up before, would the district have taken the same position and same action for that situation that it is taking now in this situation?
Yes.
And the judge asked you whether we had an area-wide management plan that was included in the record of this case here, and you responded in the negative. And my question is the facility plan that's provided in this case, we have the most recent version dated December 10th that is labeled TR1, and then we have now Commission Exhibit 307, which is an earlier iteration of the same facility plan. Is that facility plan part of the district's overall area-wide management plan for Boone County?
Yes, I would say so.
And I believe you already testified that you were involved in the process of the district obtaining approval as a level 2 continuing authority, correct?
Yes, that's correct.
And how heavily were you involved in that?
I was at the Clean Water Commission meetings. And I would say that I was pretty heavily involved in it. I know I attended some of the Clean Water Commission meetings. I may have testified at some of them. I was involved in putting together our capital improvement plan that was the basis for our level 2 continuing authority. And you know, it's my belief that the level 2 continuing authority that the Clean Water Commission granted to the sewer district included municipal facilities in a situation where a city chooses to cease owning and operating its system. In this type of situation, a city must offer the district the option to own and operate its system, and the district must decide if it's willing and able to do so.
Let me ask you this. You've already testified that there is a requirement in the regulations of the district that would require or prohibit a private system in a situation where the district was willing and able to provide services. Were those regulations, which sound consistent with the testimony about the level 2 continuing authority, were those regulations on the district's books, promulgated by the district before the continuing authority approval was sought from the Clean Water Commission?
Yes. You know, those classes of sanitary sewers were those regulations were developed and were last revised in 05 and 07. Yeah, they were last revised in 2005 and 2007.
In which, just so we know and our record is clear, what first of all, are you referencing a particular page of TR1?
I am. It begins on page 189.
And what page does it end on?
References to classes of sewer systems ends on page 191. The regulations are an entire chapter, actually.
Okay. And you've testified that the district was created by voters under the statutes. What is the voter approved territory of the district?
It is all of Boone County.
I don't have anything further at this time.
Thank you very much. Okay. Don't believe I have additional questions for Mr. Ratterman. Thank you very much for appearing today. If you will remain present for the hearing in case we need to recall you, I would appreciate that. We are going to take a break until 4:45, and then we will come back and hear from Mr. Connolly. So we are in recess now until 4:45. Thank you. Okay, Ms. Banks, how are we doing?
Good. Can you hear me this way?
I can hear you. Okay, Ms. Court Reporter, it looks like you'll be ready to go at 4:45. Is that right?
Ma'am.
Thank you. Okay, it is 4:45. We are back on the record in SA, I'm sorry, SA 2021-0017. And I believe I had excused Mr. Ratterman and thanked him for his testimony. It's unlikely we would need to recall him, but there's always that possibility. We have 2 remaining witnesses for the district, so unless anyone has anything to discuss before we get going, I believe we could take Mr. Conley's testimony. And if Mr. Conley just wants to say hello, he will pop over to my main screen. There we go.
Yes. Hello.
Hello, are you able to hear us?
Yes.
Great, we can hear and see you. So if you'll raise your right hand for me, sir. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you very much, sir.
Thank you.
Ms. Griffin, you may proceed with your witness. Thank you.
Thank you. Good afternoon, Mr. Connolly. Could you please state and spell your name for the court reporter?
Sure. Stephen, excuse me, Stephen Conley, StephenConnelley.
I think the court reporter has raised her finger for some reason. I'm not sure if she didn't catch something. Perhaps Mr. Conley could start over.
I got that, but his voice is very low. Is there any audio that he could speak up or get closer to the mic?
It looks like you're using your computer mic, so you may simply just have to speak up and project your voice in that room a little bit and irritate the people in your house, okay?
Okay.
Thank you.
Okay. Can you hear me?
Yes.
Okay.
Mr. Connolly, could you tell us by whom you are employed and in what capacity, please?
Yes, I'm president of Stephen M. Connolly, CPA PC. It's a public accounting firm in Kansas City.
And are you the same individual who caused to be prepared the rebuttal testimony of Stephen Connolly that we have pre-marked as Exhibit 201?
Yes, I am.
And do you have any additions or corrections to your rebuttal testimony?
No.
And if I were to ask you the questions contained in Exhibit 201, would your answers be the same today as they are in Exhibit 201?
Yes.
And are those answers in Exhibit 201 true and correct to the best of your knowledge and belief?
Yes.
Thank you, Mr. Connolly. At this time, the district moves to admit Exhibit 201 into the record.
Thank you. Is there any objection to the district's Exhibit 201, which is Mr. Conley's rebuttal testimony? Hearing no objection, that exhibit will be admitted. We can now proceed to any cross-examination, and we can start with staff.
Thank you, Judge. Staff has no questions at this time.
Thank you. Do we have any questions from Missouri American?
No questions, Your Honor.
Okay, thank you. It doesn't appear that I have any questions from the bench at this time for Mr. Connolly. Just taking a beat here to make sure that nobody speaks up on the commission side to let me know that there are questions. Okay, Mr. Connolly, it appears that after waiting all day, your job is now complete. Your testimony has been received. Thank you very much for being here today. You're excused. Very unlikely you would be recalled, but you never know. So as I asked other witnesses, please remain with us. We can proceed
Judge.
now. Yes. I heard a judge, so I thought someone was trying to get my attention.
I just said, thank you. Thank you.
Thank you, sir. I'm sorry for speaking over you. Thank you very much. I believe the next witness would be Mr. Stith.
I'm here.
Okay, Mr. Stith, I can see you. If you could raise your right hand. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth, sir?
I do.
Thank you very much, sir. And Ms. Griffin, you may proceed with your witness.
Thank you. Good afternoon, Mr. Stith. Could you please state and spell your name for the court reporter?
My name is Dennis Stith. First name is Dennis. Last name is Stith.
And could you tell us by whom you are employed and in what capacity?
I'm employed by McClure Engineering Company, and I am a project manager.
Are you the same individual who caused to be prepared the rebuttal testimony of Dennis Stith that we have pre-marked as Exhibit 202?
I am.
And if I were to ask you the questions contained in Exhibit 202, would your answers in that document be the same today as they are in the document?
They are.
And are those answers in Exhibit 202 true and correct to the best of your knowledge and belief?
They are.
Thank you, Mr. Stith. At this time, Boone County Regional Sewer District moves to enter and admit Exhibit 202 into the record.
Thank you. Are there any objections to admission of Exhibit 202, which is Mr. Stith's rebuttal testimony? Hearing no objections, Exhibit 202 will be admitted. Thank you very much. We can proceed now to any cross-examination from staff.
No cross from staff, Judge. Thank you.
And any cross-examination from Missouri American.
No, Judge.
Thank you very much. There will be one question from the bench at this point for Mr. Stith. Sir, it appears that in your testimony, one of your criticisms of Missouri American's application is that it doesn't include a specific proposal to upgrade or expand the system. Would you agree with that characterization?
Yes.
So are you familiar with the permitting process before Department of Natural Resources?
Yes.
Is the need for expansion of the system something that would be expected to be considered by DNR in reviewing a construction or operation permit application?
My experience is that it has been expected to look at, the expansion that may be needed.
Okay, thank you. And what about upgrades? Is that something that is going to be considered by DNR?
Yes, upgrades will be considered.
Okay, thank you very much. I'm going to pause here for a minute and see if there are any questions from commissioners. Based on that single question that I asked, did staff have any questions they would like to ask of Mr. Stith?
No, Judge. Thank you.
And the company? Missouri American.
Yeah, I'm sorry, Judge, a little slow getting to the unmute button there. One question. Mr. Stith, would you agree that Hallsville has no current plan to address its issues, no estimated cost of addressing them, no financing, and no idea of what impact any of that would have on its customer rates?
I have not seen any information along those lines that would indicate what Hallsville would have in mind going forward if it was their system.
Okay. Thank you.
Okay, thank you. Do we have any redirect by the district for Mr. Stith?
No, Judge.
Okay, thank you very much. Mr. Stith, thank you so much for appearing here today. It seems that you are our final witness, and so you are truly and genuinely excused along with all of our other witnesses. So thank you so much for being with us today and providing testimony. Okay, it appears that we have arrived at the final matters portion of our hearing. There's one issue I wanted to bring up, and this concerns the Missouri Americans exhibit list, and just something that's going to help when the adjudication staff gets around to filing those marked exhibits. I believe that the company's exhibit list, because there was a problem with the page numbering when Mr. Horan's Sir rebuttal was filed, the company was directed to file that again. And then your exhibit list actually refers to the schedules that were attached when that was initially filed. My understanding, however, is that those schedules should be perfectly identical in every way. So is there any reason that they wouldn't be, just for the simplicity of instructing the adjudication staff in how those documents are gathered and then refiled as a marked exhibit? Do you understand what I'm asking, Mr. Cooper?
Not necessarily. When I did this list, it looked to me like under item 41, we just had the corrected pieces of Mr. Horan's testimony. Subsequently, when I looked at item 41, it looked like the schedules for his testimony had been included in 41. And if that's the case, I think we can just refer to 41.
Okay. That maybe there was something that happened behind the curtain with that filing, who knows, but you, as long as you haven't filed any new schedules that would have changed anything, I just want to be able to treat those as the same and just simplify that. And so it doesn't sound like you have any reason to believe those schedules are any different.
No, they should not be. They are not.
And does any other party have any concerns about that or questions about what we're talking about?
And Judge, this is Jennifer Hernandez. I filed all that according to the commission's order, and all I did was put page numbers on the testimony. I didn't change anything else.
Okay, so perhaps what happened is someone in the data center looked at that and thought, oh, that's not full. I can't say that's what happened, and we always appreciate their help. So perhaps that's what happened. So thank you. I will know how to handle that going forward. As far as commission exhibits go, I just want to make sure that I've clarified that exhibit commission 306 is going to be that April 7 order the commission just issued in WR 2020-0344. There are going to be some kind of gaps in our exhibit numbers, but that's okay. It's not a big deal. And then the only other comment I would have to do with briefing. So, but before we get to that, we are going to be seeing from the company an Exhibit 8 by the 12th that's going to give us that vote tally. And transcripts should be available in this case by April 22nd. And we have post-hearing briefs ordered for initial briefs on May 4th, reply briefs May 11th. Are those dates still acceptable for the parties? Okay, so Mr. Pringle, I saw you move. So are you needing to say something?
Just double checking because I knew I had a few extra hearings scheduled, but I think that still works. Just going to check my calendar real fast.
I'm happy to let you check your calendar.
Yep, we're all good.
Okay, so no concerns about shifting those dates. One mention that I wanted to make when it comes to briefing is that in regard to the district, Ms. Griffin, we did hear some testimony today about the district's planning authority and about district regulations. And I have not seen that articulated in the case to this point, perhaps in a way that I have really been able to understand that. I think that's something that it would be helpful if the briefs addressed. So that's just a request as far as something that maybe isn't as clear coming into hearing as it could have been. That I'm going to need some help
Sure.
with. Okay.
I'm happy to address it. That was part of the reason I wanted to ask him some additional questions to lay that out better. But it came in the way that it came in, and I'll do the best I can to clarify in the briefing.
Okay. I do think to a very great extent, it seems to be legal questions, and so hopefully they can be handled effectively in a brief. Okay, so those are the only things that I had to talk about before we wrapped up. Did anyone have anything else? Okay, well, it's 4:59. So thank you all so much for being here. I really appreciate it. It was a beautiful day for a hearing. So I hope you all have a good evening. We are off the record.
Thank you.
Thank you, Judge.
Thank you, Judge. Thank you, everyone.
Thank you.
Thank you.